The Malleus Maleficarum. Part 3, the third head. Which is the last part of the work, how the process is to be concluded by the pronouncement of a definite and just sentence. Having by the grace of God examined the proper means of arriving at a knowledge of the heresy of witchcraft, and having shown how the process on behalf of the faith should be initiated and proceeded with, it remains to discuss how that process is to be brought to a fitting termination with an appropriate sentence. Here it is to be noted that this heresy, as was shown in the beginning of this last part, is not to be confused with other simple heresies, since it is obvious that it is not a pure and single crime, but partly ecclesiastical and partly civil. Therefore, in dealing with the methods of passing sentence, we must first consider a certain kind of sentence to which witches are in the habit of appealing, in which the secular judge can act on his own account independently of the ordinary. Secondly, we shall consider those in which he cannot act without the ordinary. And so thirdly, it will be shown how the ordinaries can discharge themselves of their duties. The Malleus Maleficarum. Part 3, third head, question 17. Of common purgation, and especially of the trial of red-hot iron, to which witches appeal. The question is now asked whether the secular judge may allow a witch to be submitted to a common purgation, concerning which see the canon 2, Q. 4, Consoluisti, and Cap. Monomachiem, in the manner in which a civil defendant is allowed the trial by ordeal, as, for example, that by red-hot iron. And it may seem that he may do so. For trial by combat is allowable in a criminal case for the protection of life, and in a civil case for the protection of property, then wherefore not the trial by red-hot iron or boiling water? S. Thomas allows that the former is permissible in some cases, when he says in the last article of the 2nd of the 2nd, Q. 95, that a duel is lawful when it appears to be consonant with common sense. Therefore the trial by red-hot iron should also be lawful in some cases. Also it has been used by many princes of saintly life who have availed themselves of the advice and counsel of good men, as, for example, the sainted Emperor Henry in the case of the Virgin Cunegond whom he had married, who was suspected of adultery. Again, a judge, who is responsible for the safety of the community, may lawfully allow a smaller evil that a greater may be avoided, as he allows the existence of harlots in towns in order to avoid a general confusion of lust. 4s. Augustine on Free Will says, "Take away the harlots, and you will create a general chaos and confusion of lust." So, when a person has been loaded with insults and injuries by any community, he can clear himself of any criminal or civil charge by means of a trial by ordeal. Also, since less hurt is caused to the hands by the red-hot iron than is the loss of life in a duel, if a duel is permitted where such things are customary, much more should the trial by red-hot iron be allowed. But the contrary view is argued where it says, 2, Q. 5, Monomachiem, that they who practice such and similar things appear to be tempting God. And here the doctors affirm it must be noted that, according to S. Paul, I. Thessalonians v, we must abstain, not only from evil, but from all appearance of evil. Therefore the canon says in that chapter, not that they who use such practices tempt God, but that they appear to tempt him, so that it may be understood that, even if a man engage in such a trial with none but good intentions, yet since it has the appearance of evil, it is to be avoided. I answer that such tests or trials are unlawful for 2 reasons. First, because their purpose is to judge of hidden matters of which it belongs only to God to judge. Secondly, because there is no divine authority for such trials, nor are they anywhere sanctioned in the writings of the Holy Fathers. And it says in the chapter Consuetusti, 2, q. 5, that which is not sanctioned in the writings of the sainted fathers is to be presumed superstitious. And Pope Stephen in the same chapter says, it is left to your judgment to try prisoners who are convicted by their own confession or the proofs of the evidence, but leave that which is hidden and unknown to him who alone knows the hearts of men. There is, nevertheless, a difference between a duel and the trial by red-hot iron or boiling water. For a duel appears to be more humanly reasonable, the combatants being of similar strength and skill, than a trial by red-hot iron. For although the purpose of both is to search out something hidden by means of a human act, yet in the case of trial by red-hot iron a miraculous effect is looked for, whereas this is not so in the case of a duel, in which all that can happen is the death of either, or both, of the combatants. Therefore the trial by red-hot iron is altogether unlawful, though a duel is not illegal to the same extent. So much has been incidentally admitted in respect of duels, on account of princes and secular judges. It is to be noted that, because of those words of S. Thomas which make the above distinction, Nicholas of Lyra, in his commentary on the duel or combat between David and Goliath, I. Regum 17, tried to prove that in some cases a duel is lawful. But Paul of Burgos proves that not this, but rather the opposite was the meaning of S. Thomas, and all princes and secular judges ought to pay particular attention to his proof. His first point is that a duel, like the other trial by ordeal, has as its purpose the judgment of something hidden, which ought to be left to the judgment of God, as we have said. And it cannot be said that this combat of David is an authority for dueling, for it was revealed to him by the Lord through some inner instinct that he must engage in that combat and avenge upon the Philistine the injuries done against God. As is proved by David's words, I come against thee in the name of the living God. So he was not properly speaking a duelist, but he was an executor of divine justice. His second point is that judges must especially note that in a duel power, or at least license, is given to each of the parties to kill the other. But since one of them is innocent, that power of license is given for the killing of an innocent man, and this is unlawful, as being contrary to the dictates of natural law and to the teaching of God. Therefore, a duel is altogether unlawful, not only on the part of the appellant and the respondent, but also on the part of the judge and his advisers, who are all equally to be considered homicides or parties to manslaughter. Thirdly, he points out that a duel is a single combat between two men, the purpose of which is that the justice of the case should be made clear by the victory of one party, as if by divine judgment. Notwithstanding the fact that one of the parties is fighting in an unjust cause, and in this way God is tempted. Therefore it is unlawful on the part both of the appellant and the respondent. But considering the fact that the judges have other means of arriving at an equitable and just termination of the dispute, when they do not use such means, but advise or even permit a duel when they could forbid it, they are consenting to the death of an innocent person. But since it is unlikely that Nicholas the commentator was unaware or ignorant of the above reasoning, it is concluded that, when he says that in some cases a duel can be fought without mortal sin, he is speaking on the part of the judges or advisers, namely, in a case when such a trial is undertaken, not on their responsibility or advice, but purely on that of the appellant and respondent themselves. But since it is not our purpose to linger over and debate such considerations, but to return to the question of witches, it is clear that, if this sort of trial is forbidden in the case of other criminal causes, such as theft or robbery, still more must it be forbidden in the case of witches who, it is agreed, obtain all their power from the devil, whether it be for causing or curing an injury, for removing or for preventing an effect of witchcraft. And it is not wonderful witches are able to undergo this trial by ordeal unscathed with the help of devils, for we learn from naturalists that if the hands be anointed with the juice of a certain herb they are protected from burning. Now the devil has an exact knowledge of the virtues of such herbs, therefore, although he can cause the hand of the accused to be protected from the red-hot iron by invisibly interposing some other substance, yet he can procure the same effect by the use of natural objects. Hence even less that other criminals ought witches to be allowed this trial by ordeal, because their intimate familiarity with the devil, and from the very fact of their appealing to this trial they are to be held as suspected witches. An incident illustrative of our argument occurred hardly 3 years ago in the Diocese of Constance. For in the territory of the Counts of Fürstenberg and the Black Forest there was a notorious witch who had been the subject of much public complaint. At last, as the result of a general demand, she was seized by the Count and accused of various evil works of witchcraft. When she was being tortured and questioned, wishing to escape from their hands, she appealed to the trial by red-hot iron, and the Count, being new and inexperienced, allowed it. And she then carried the red-hot iron not only for the stipulated 3 paces, but for 6, and offered to carry it even farther. Then, although they ought to have taken this as manifest proof that she was a witch, since one of the saints dared to tempt the help of God in this manner, she was released from her chains and lives to the present time, not without grave scandal to the faith in those parts. Part 3, Third Head, Question 13. Of the manner of pronouncing a sentence which is final and definitive. In proceeding to treat of those cases in which the secular judge by himself can arrive at a judgment and pronounce a sentence without the cooperation of the diocesan and ordinaries, we necessarily presuppose that not only is it consistent with the protection of the faith and of justice that we inquisitors should be relieved of the duty of passing sentence in these cases, but in the same sincerity of spirit we endeavor to relieve the diocesans also from that duty, not in any desire to detract from their authority and jurisdiction, for if they should elect to exercise their authority in such matters, it would follow that we inquisitors must also concur in it. It must be remembered, also, that this crime of witches is not purely ecclesiastic, therefore the temporal potentates and lords are not debarred from trying and judging it. At the same time we shall show that in some cases they must not arrive at a definitive judgment without the authorization of the diocesans. But first we must consider the sentence itself, secondly, the nature of its pronouncement, and thirdly, in how many ways it is to be pronounced. With regard to the first of these questions, S. Augustine says that we must not pronounce sentence against any person unless he has been proved guilty, or has confessed. Now there are 3 kinds of sentence: interlocutory, definitive, and preceptive. These are explained as follows by S. Raymond. An interlocutory sentence is one which is given not on the main issue of the case, but on some other side issues which emerge during the hearing of a case, such as a decision whether or not a witness is to be disallowed, or whether some digression is to be admitted, and such matters as that. Or it may perhaps be called interlocutory because it is delivered simply by word of mouth without the formality of putting it into writing. A definitive sentence is one which pronounces a final decision as to the main issue of the case. A preceptive sentence is one which is pronounced by a lower authority on the instruction of a higher. But we shall be concerned with the first 2 of these, and especially with the definitive sentence. Now it is laid down by law that a definitive sentence which has been arrived at without a due observance of the proper legal procedure in trying a case is null and void in law, and the legal conduct of a case consists in 2 things. One concerns the basis of the judgment, For there must be a due provision for the hearing of arguments both for the prosecution and the defense, and a sentence arrived at without such a hearing cannot stand. The other is not concerned with the basis of the judgment, but provides that the sentence must not be conditional. For example, a claim for possession should not be decided conditionally upon some subsequent claim of property, but where there is no question of such an objection the sentence shall stand. But in the case we are considering, which is a process on behalf of the faith against a charge of heresy, though the charge is a mixed one, the procedure is straightforward and summary. That is to say, the judge need not require a writ, or demand that the case should be contested. But he must allow opportunity for the necessary proofs, and issue his citation, and exact the protestation of the oath concerning calumny, etc. Therefore there has lately been a new law made as to the method of procedure in such cases. To proceed to our second consideration, namely, of the nature of the pronouncement of the sentence, it must be noted that it should be pronounced by the judge and no one else, otherwise it is not valid. Also the judge must be sitting in a public and honorable place, and he must pronounce it in the daytime and not in the darkness, and there are other conditions to be observed. For example, the sentence must not be promulgated upon a holy day, nor yet merely delivered in writing. Yet it is to be noted that since, as we have said, this case is conducted in a simple and summary manner, it may lawfully be conducted on holy days for the sake of the convenience of the public, and the judge may cut short any digressions. Therefore the judge may, if he pleases, act in such a manner, and even pass sentence without putting it in writing. For we are authoritatively informed that there are cases in which a sentence is valid without its being put into writing, as, for example, when such is the custom of any particular locality or court. Also there is excellent precedent for a bishop, when he is the judge, allowing the sentence to be pronounced by some other person. Note again that, although in criminal actions the execution of the sentence is not to be delayed, this rule does not hold good in 4 cases, with 2 of which we are here concerned. First, when the prisoner is a pregnant woman, and then the sentence shall be delayed until she has given birth. Secondly, when the prisoner has confessed her crime, but has afterwards denied it again, that is to say, when the way which we explained in the 14th question. Now before we proceed to our third consideration, namely, the different methods of passing sentence which we shall proceed to treat of up to the end of this work, we must first make some remarks about the various ways in which a prisoner is rendered suspect, from which the various methods of passing sentence follow as a consequence. Part 3, Third Head, Question 19. Of the various degrees of overt suspicion which render the accused liable to be sentenced. Both the old and the new legislature provide an answer to the question as to in how many and what ways a person can be held suspect of heresy or any other crime, and whether they can be judged and sentenced by reason of such suspicions. For the gloss on the chapter Nos in Quem Quam, which we quoted in the last question, says that there are 4 means of convicting a prisoner, either by the depositions of witnesses in court, or by the evidence of the facts, or by reason of previous convictions against the prisoner, or because of a grave suspicion. And the canonists note that suspicion is of 3 kinds. The first of which the canon says, "You shall not judge anyone because he is suspect in your own opinion." The second is probably, and this, but not the first, leads to a purgation. The third is grave, and leads to a conviction, and s. Jerome understands this kind of suspicion when he says that a wife may be divorced either for fornication or for a reasonably suspected fornication. It must further be noted that the second, or highly probable and circumstantial, suspicion is admitted as a kind of half-proof, that is to say, it helps to substantiate other proofs. Therefore it can also lead to a judgment, and not only to a purgation. And as for the grave suspicion, which suffices for a conviction, note that it is of two kinds. One is of the law and by the law, as when the law fixes and determines some point against which no proof can be admitted. For example, if a man has given a woman a promise of matrimony, and copulation has ensued, then matrimony is presumed, and no proof to the contrary is admitted. The second is of the law but not by the law, as where the law presumes but does not determine a fact. For example, if a man has lived for a long time with a woman, she is presumed to have had connection with him, but against this proofs are admitted. Applying this to our discussion of the heresy of witches and to the modern laws, we say that in law there are 3 degrees of suspicion in the matter of heresy, the first slight, the second great, and the third very great. The first is in law called a light suspicion. Of this it is said in the chapter XXIII, Deharit. Lib. 6, if the accused has incurred only a light and small suspicion, and if she should again fall under that suspicion, although she is to be severely punished for this, she ought not to suffer the punishment of those who have relapsed into heresy. And this suspicion is called small or light, both because it can be removed by a small and light defense, and because it arises from small and light conjectures. Therefore it is called small, because of the small proofs of it, and light, because of the light conjectures. As an example of simple heresy, if people are found to be meeting together secretly for the purpose of worship, or differing in their manner of life and behavior from the usual habits of the faithful, or if they meet together in sheds and barns, or at the more holy seasons in the remoter fields or woods, by day or by night, or are in any way found to separate themselves and not to attend Mass at the usual times or in the usual manner, or form secret friendships with suspected witches, such people incur at least a light suspicion of heresy. Because it is proved that heretics often act in this manner. And of this light suspicion the canon says, they who are by a slight argument discovered to have deviated from the teaching and path of the Catholic religion are not to be classed as heretics, nor is a sentence to be pronounced against them. Henry of Seggio agrees with this in his Summa, de Presumption, where he says, it is to be noted that although a heretic be convicted by a slight argument of that matter of which he is suspected, he is not on that account to be considered a heretic, and he proves it by the above reasoning. The second or grave suspicion is in law called grave or vehement, and of this the above canon, XXIII, again says, one who is accused or suspected of heresy, against whom a grave or vehement suspicion of this crime has arisen, etc. And it goes on, and these are not 2 kinds but the same kind of suspicion. Giovanni d'Andrea also says, vehement is the same as strong, as the archdeacon says speaking of this canon. Also Bernardus Papiensis and Huguicho say that vehement is the same as strong or great. S. Gregory also, in the first book of his Morals says, a vehement wind sprang up. Therefore we say that anyone has a vehement case when he has a strong one. So much for this. Therefore a great suspicion is called vehement or strong, and it is so called because it is dispelled only by a vehement and strong defense, and because it arises from great, vehement, and strong conjectures, arguments, and evidence. As, to take an example of simple heresy, when people are found to shelter known heretics, and show favor to them, or visit and associate with them and give gifts to them, receive them into their houses and protect them, and such like, such people are vehemently suspected of heresy. And similarly in the heresy of witches, they are brought under suspicion when they share in the crimes of witches. And here are especially to be noted those men or women who cherish some inordinate love or excessive hatred, even if they do not use to work any harm against men or animals in other ways. For, as we have said, those who behave in this way in any heresy are strongly to be suspected. And this is shown by the canon, where it says that there is no doubt that such persons act in this way out of some heretical sympathy. The third and greatest suspicion is in law called grave or violent, for the canon and the glosses of the Archdeacon and Giovanni d'Andrea explain that the word vehement does not mean the same as the word violent. And of this suspicion the canon says, dist. 34 This presumption or suspicion is called violent because it violently constrains and compels a judge to believe it, and cannot be cast off by any evasion, and also because it arises from violent and convincing conjectures. For example, in simple heresy, if persons are found to show a reverent love for heretics, to receive consolation or communion from them, or perpetrate any other such matter in accordance with their rites and ceremonies, such persons would fall under and be convicted of a violent suspicion of heresy and heretical beliefs. See many chapters on this subject in Book 6 of the Canon. For there is no doubt that such persons act in this way out of a belief in some heresy. It is the same, as regards the heresy of witches, with those who perform and persist in performing any of the actions which pertain to the rites of witches. Now these are of various kinds. Sometimes it is only some threatening speech, such as "you shall soon feel what will happen to you," or something similar. Sometimes it is a touch, just laying their hands curiously on a man or a beast. Sometimes it is only a matter of being seen, when they show themselves by day or by night to others who are sleeping in their beds, and this they do when they wish to bewitch men or beasts. But for raising hailstorms they observe various other methods and ceremonies, and perform various ritual actions round about a river, as we have shown before where we discussed the manner and methods of working witchcraft. When such are found and are publicly notorious, they are convicted of a violent suspicion of the heresy of witchcraft, especially when some effect of witchcraft has followed upon their actions, either immediately or after some interval. For then there is direct evidence when any instruments of witchcraft are found hidden in some place. And although when some interval of time has elapsed the evidence of the fact is not so strong, such a person still remains under strong suspicion of witchcraft, and therefore much more of simple heresy. And if it be asked whether the devil cannot inflict injury upon men and beasts without the means of a woman being seen in a vision or by her touch, we answer that he can, when God permits it. But the permission of God is more readily granted in the case of a creature that was dedicated to God, but by denying the faith has consented to other horrible crimes, and therefore the devil more often uses such means to harm creatures. Further, we may say that, although the devil can work without a witch, he yet very much prefers to work with one, for the many reasons which we showed earlier in this work. To sum up our conclusions on this matter, it is to be said that, following the above distinctions, those who are suspected of the heresy of witchcraft are separated into three categories, since some are lightly, some strongly, and some gravely suspected. And they are lightly suspected who act in such a way as to give rise to a small or light suspicion against him of this heresy. And although, as has been said, a person who is found to be suspected in this way is not to be branded as a heretic, yet he must undergo a canonical purgation, or he must be caused to pronounce a solemn abjuration as in the case of one convicted of a slight heresy. For the canon, cap. Excommunicamus, says, those who have been found to rest under a probable suspicion, that is, says Henry of Seggio, a light suspicion, unless, having respect to the nature of the suspicion and the quality of their persons, they should prove their innocence by a fitting purgation. they are to be stricken with the sword of anathema as a worthy satisfaction in the sight of all men. And if they continue obstinate in their excommunication for the period of a year, they are to utterly condemned as heretics. And note that, in the purgation imposed upon them, whether or not they consent to it, and whether or not they fail in it, they are throughout to be judged as reputed heretics on whom a canonical purgation is to be imposed. And that a person under this light suspicion can and should be caused to pronounce a solemn abjuration is shown in the chapter XXIII, where it says, "A person accused or suspected of heresy, against whom there is a strong suspicion of this crime. If he abjures the heresy before the judge and afterwards commits it, then, by a sort of legal fiction, he shall be judged to have relapsed into heresy, although the heresy was not proved against him before his abjuration. But if the suspicion was in the first place a small or light one, although such a relapse renders the accused liable to severe punishment, yet he is not to suffer the punishment of those who relapse into heresy. But those who are strongly suspected, that is, those who have acted in such a way as to engender a great and strong suspicion, even those are not necessarily heretics or to be condemned as such. For it is expressly stated in the canon that no one is to be condemned of so great a crime by reason of a strong suspicion. And it says, "Therefore we order that, when the accused is only under suspicion, even if it be a strong one, we do not wish him to be condemned of so grave a crime, but such a one so strongly suspected must be commanded to abjure all heresy in general, and in particular that of which he is strongly suspected. But if he afterwards relapses either into his former heresy or into any other, or if he associates with those whom he knows to be witches or heretics, or visits them, receives, consults with, forgives, or favors them, he shall not escape the punishment of backsliders." According to the chapter XXIII. For it says there, "He who has been involved in one kind or sect of heresy, or has erred in one article of the faith or sacrament of the Church, and has afterwards specifically and generally abjured his heresy, if thereafter he follows another kind or sect of heresy, or errs in another article or sacrament of the Church, it is our will that he be judged a backslider. He, therefore, who is known to have lapsed into heresy before his abjuration, if after his abjuration he receives heretics, visits them, gives or sends them presents or gifts, or shows favor to them, etc., he is worthily and truly to judge a backslider, for by this proof there is no doubt that he was in the first place guilty." Such is the tenor of the canon. From these words it is clear that there are three cases in which a person under strong suspicion of heresy shall, after his abjuration, be punished as a backslider. The first is when he falls back into the same heresy of which he was strongly suspected. The second is when he has abjured all heresy in general, and yet lapses into another heresy, even if he has never before been suspected or accused of that heresy. The third is when he receives and shows favor to heretics. And this last comprises and embraces many cases. But it is asked what should be done when a person who has fallen under so strong a suspicion steadily refuses to comply with his judge's order to abjure his heresy. Is he to be at once handed over to the secular court to be punished? We answer that by no means must this be done, for the canon, ad abolendum, expressly speaks, not of suspects, but of those who are manifestly taken in heresy. And more rigorous action is to be employed against those who are manifestly taken than against those who are only suspected. And if it is asked, how then is such a one to be proceeded against? We answer that the judge must proceed against him in accordance with the chapter excommunicamus, and he must be excommunicated. And if he continues obstinate after a year's excommunication, he is to be condemned as a heretic. There are others again who are violently or gravely suspected, whose actions give rise to a violent suspicion against them, and such a one is to be considered as a heretic, and throughout he is to be treated as if he were taken in heresy, in accordance with the canon law. For these either confess their crime or not, and if they do, and wish to return to the faith and abjure their heresy, they are to be received back into penitence. But if they refuse to abjure, they are to be handed over to the secular court for punishment. But if he does not confess his crime after he has been convicted, and does not consent to abjure his heresy, he is to be condemned as an impenitent heretic. For a violent suspicion is sufficient to warrant a conviction, and admits no proof to the contrary. Now this discussion deals with simple heresy, where there is no direct or indirect evidence of the fact, as will be shown in the sixth method of passing sentence. Where a man is to be condemned as a heretic even though he may not actually be one, then how much more is it applicable to the heresy of witches, where there is always in addition either the direct evidence of bewitched children, men, or animals, or the indirect evidence of instruments of witchcraft which have been found. And although in the case of simple heresy those who are penitent and abjure are, as has been said, admitted to penitence and imprisonment for life, yet in this heresy, although the ecclesiastic judge may receive the prisoner into penitence, yet the civil judge can, because of her temporal injuries, that is to say, the harms she has done to men, cattle, and goods, punish her with death, nor can the ecclesiastic judge prevent this, for even if he does not hand her over to be punished, yet he is compelled to deliver her up at the request of the civil judge. Part 3, Third Head, Question XX. Of the first method of pronouncing sentence. Since, therefore, the accused is either found innocent and is to be altogether absolved, or is found only to be generally defamed as a heretic, or is found a proper subject for the questions and the torture on account of her reputation, or is found to be lightly suspected of heresy, or is found to be strongly or gravely suspected of heresy, or is found to be at the same time commonly defamed and suspected of heresy, or is found to have confessed her heresy and to be penitent but probably to have relapsed, or is found to have confessed her heresy and to be impenitent but not really to have relapsed, or is found to have confessed but by legitimate witnesses and otherwise legally to have been convicted of heresy, or is found to have been convicted of heresy but to have escaped or defiantly absented herself, or is found not to have done injury by witchcraft but to have removed bewitchments unfittingly and by unlawful means, or is found to be an archer, wizard, or enchanter of weapons with the purpose of causing death, or is found to be a witch midwife offering infants to the devil in the manner of an enemy, or is found to make frivolous and fraudulent appeals with a view to saving her life. Therefore, if she is found to be entirely innocent, the final sentence shall be pronounced in the following manner. Here it is to be noted that the accused is found to be entirely innocent when, after the facts of the process have been diligently discussed in consultation with skilled lawyers, she cannot be convicted either by her own confession, or by the evidence of the fact, or by the production of legitimate witnesses, since they have disagreed upon the main issue. And when the accused has never before been suspected of or publicly defamed as regards that crime, but the case is different if she has been defamed as regards some other crime, and when there is no evidence of the fact against her. In such a case the following procedure is observed, for she is to be absolved by the bishop or judge by a sentence to the following effect: we n, by the mercy of God, bishop of such a town, or judge, etc. Considering that un of such a place and such a diocese have been accused before us of the crime of heresy, and namely of witchcraft, and considering that this accusation was such as we could not pass over with connivant eyes, have condescended to inquire whether the aforesaid accusation can be substantiated as true. By calling witnesses, by examining you, and by using other means which are fitting according to the canonical sanctions. Wherefore, having diligently seen and examined all that has been done and said in this case, and having had the counsel of learned lawyers and theologians, and having repeatedly examined and inquired into all, sitting as judges on this tribunal, and having only God before our eyes and the truth of the case, and the holy Gospels being placed before us, that our judgment may proceed from the countenance of God and our eyes behold equity, we proceed to our definitive sentence in this way, invoking the name of Christ. Since by that which we have seen and heard, and has been produced, offered, done, and executed before us in this present case, we have not found that anything has legally been proved against you of those things of which you were accused before us, we pronounce, declare, and give it as our final sentence, that no act has legally been proved to us against you by which you can or ought to be judged a heretic or witch of heresy. Wherefore, by this present declaration, inquiry, and judgment, we freely discharge you. This sentence was given, etc. Let care be taken not to put anywhere in the sentence that the accused is innocent or immune, but that it was not legally proved against him. For if after a little time he should again be brought to trial, and it should be legally proved, he can, notwithstanding the previous sentence of absolution, then be condemned. Note also that the same method of absolution may be used in the case of one who is accused of receiving, protecting, or otherwise comforting and favoring heretics, when nothing is legally proved against him. A secular judge commissioned by the bishop shall use his own manner of pronouncement. Part 3, Third Head, Question XXII. Of the second method of pronouncing sentence, when the accused is no more than defamed. The second method of delivering judgment is to be employed when he or she who is accused, after a diligent discussion of the merits of the case in consultation with learned lawyers, is found to be no more than defamed as a heretic in some village, town, or province. And this is when the accused does not stand convicted either by her own confession, or by the evidence of the facts, or by the legitimate production of witnesses, nor has there been anything proved against her except that she is the subject of common aspersion, so that no particular act of witchcraft can be proved by which she can be brought under strong or grave suspicion. As that she has uttered threatening words, for example, "You will soon feel what will happen to you," or something to that effect, and afterwards some injury has befallen the person or the cattle of the man she threatened. The following procedure, therefore, is to be employed in the case of such a one against whom nothing has been proved except public obloquy. In this case judgment cannot be delivered for the accused, nor can she be absolved as in the first method, but a canonical purgation must be imposed upon her. Therefore let the bishop or his deputy, or the judge, first take note that, in a case of heresy, it is not necessary that a person should be defamed only by good and respected people, for the calumniation uttered by common and simple folk carries equal weight. And the reason for this is, that the same persons who are admitted as accusers in a case of heresy are also admitted as detractors. Now any heretic can be accused by anybody, except his mortal enemies, therefore he can also be defamed by anybody. Therefore let the bishop or judge pronounce his sentence of canonical purgation in this or some similar manner, by the mercy of God, bishop of such a city, or judge of such a county, having diligently examined the merits of the process conducted by us against UN. Of such a diocese accused before us of the crime of heresy, etc. We have not found that you have confessed to or have been convicted of the aforesaid sin, or that you are even lightly suspected of it, except that we find that truly and legitimately you are publicly defamed by both good and bad in such a village, town, or diocese, and that you may be in good odor among the company of the faithful, we impose upon you as by law a canonical purgation, assigning to you such a day of such a month at such hour of the day, upon which you shall appear in person before us with so many persons of equal station with you to purge you of your defamation. Which sponsors must be men of the Catholic faith and of good life, who have known your habits and manner of living not only recently but in time past. And we signify that, if you should fail in this purgation, we shall hold you convicted, according to the canonical sanctions. Here it is to be considered that, when a person is duly found to be publicly defamed of some heresy, and nothing is proved against him except that defamation, a canonical purgation shall be imposed upon him. That is, he must produce some 7, 10, 20, or 30 men, according to the extent to which he has been defamed and the size and importance of the place concerned, and these must be men of his own station and condition. For example, if he who is defamed is a religious, they must be religious; if he is a secular, they must be seculars; if he be a soldier, they must be soldiers who purge him from the crime for which he is defamed. And these sponsors must be men professing the Catholic faith and of good life, who have known his habits and life both recently and for a long time. But if he refuses this purgation, he must be excommunicated, and if he remains obstinate in that excommunication for a year, he is then to be condemned as a heretic. And if he accepts the purgation and fails in it, that is, if he cannot find sponsors of the number and quality desired, he shall be considered as convicted, and is to be condemned as a heretic. And it must here be remarked that, when it is said that he must purge himself by means of so many men of his own station in life, this is meant generically and not specifically. Thus, if a bishop is to be purged, it is not necessary that all his sponsors should be bishops, but abbots and other religious who are priests are admitted, and similarly in other cases. And the defamed person shall purge himself in the following manner. At the time assigned to him for his canonical purgation, he shall appear in person with his sponsors before the bishop who is his judge, in the place where he is known to be defamed, and, placing his hand upon the book of the Gospel set before him, he shall say as follows: I swear upon these 4 holy Gospels of God that I never held, believed, or taught, neither do I hold or believe such heresy, naming it, for which I am defamed. That is to say, he shall deny on oath whatever it is for which he is defamed. After this, all his sponsors shall place their hands on the Gospels, and each of them severally shall say, and I swear upon this holy Gospel of God that I believe him to have sworn the truth. And then he is canonically purged. It is also to be noted that a person defamed of heresy is to be purged in the place where he is known to be defamed. And if he has been defamed in many places, he must be required to profess the Catholic faith and deny the heresy in all the places in which he is known as defamed. And let not such a person hold in light esteem this canonical purgation. For it is provided by the canon law that, if he afterwards falls into the heresy of which he has been purged, he is to be handed over as a backslider to the secular court. But the case is somewhat different if he falls into some other heresy, of which he has not before been purged. Part 3, Third Head, Question XXII. Of the third kind of sentence, to be pronounced on one who is defamed, and who is to be put to the question. The third method of bringing a process on behalf of the faith to a conclusive termination is when the person accused of heresy, after a careful consideration of the merits of the process in consultation with learned lawyers, is found to be inconsistent in his statements, or is found that there are sufficient grounds to warrant his exposure to the question and torture, so that if, after he has been thus questioned, he confesses nothing, he may be considered innocent. And this is when the prisoner has not been taken in heresy, nor has he been convicted by his own confession, or by the evidence of the facts, or by the legitimate production of witnesses. And there are no indications that he is under such a suspicion as to warrant his being made to abjure the heresy, but nevertheless he is inconsistent in his answers when interrogated. Or there may be other sufficient reasons for exposing him to torture. And in such a case the following procedure is to be observed. And because such a judgment includes an interlocutory sentence which must be against and not for the prisoner, the inquisitor must not divide it into two sentences, but include it all in one. And in the first place, if the accused remains firm in his denials and can in no way be induced by honest men to confess the truth, the following manner of sentence, which is in some respects definitive, shall be used. We n. By the mercy of God, bishop of such a town, or judge in the territory subject to the rule of such a prince, having regard to the merits of the process conducted by us against UN, of such a place in such a diocese, and after careful examination, find that you are not consistent in your answers, and that there are sufficient indications besides that you ought to be exposed to the question and torture. Therefore, that the truth may be known from your own mouth, and that from henceforth you may not offend the ears of your judges with your equivocations, we declare, pronounce, and give sentence that on this present day at such an hour you are to be subjected to an interrogatory under torture. This sentence was given, etc. If the person to be questioned is both found to be equivocal and at the same time there are other indications sufficient to warrant his being tortured, let both these facts be included in the sentence, as they are above. But if only one or the other of these hold good, let that one only be put in the sentence. But let the sentence be soon put into execution, or let them make as if to execute it. Nevertheless, let not the judge be too willing to subject a person to torture, for this should only be resorted to in default of other proofs. Therefore let him seek for other proofs, and if he cannot find them, and thinks it probable that the accused is guilty, but denied the truth out of fear, let him use other approved methods, always with due precautions. And by using the persuasions of the friends of the accused do his utmost to extract the truth from his own lips. And let him not hasten the business, for very often meditation, and the ordeal of imprisonment, and the repeated persuasion of honest men will induce the accused to discover the truth. But if, after keeping the accused in suspense, and after due and decent postponements of the time, and many exhortations of the accused, the bishop and the judge are well persuaded that, all circumstances considered, the accused is denying the truth, let them torture him slightly, without shedding blood, bearing in mind that torture is often fallacious and ineffective. For some are so soft-hearted and feeble-minded that at the least torture they will confess anything, whether it be true or not. Others are so stubborn that, however much they are tortured, the truth is not to be had from them. There are others who, having been tortured before, are the better able to endure it a second time, since their arms have been accommodated to the stretchings and twistings involved, whereas the effect on others is to make them weaker, so that they can the less easily endure torture. Others are bewitched, and make use of the fact in their torture, so that they will die before they will confess anything, for they become, as it were, insensible to pain. Therefore there is need for much prudence in the matter of torture, and the greatest attention is to be given to the condition of the person who is to be tortured. When, then, the sentence has been pronounced, the officers shall without delay prepare to torture the accused. And while they are making their preparations, the bishop or judge shall use his own persuasions and those of other honest men zealous for the faith to induce the accused to confess the truth freely, if necessary promising to spare his life, as we have shown above. But if the accused cannot thus be terrified into telling the truth, a second or third day may be appointed for the continuation of the torture, but it must not be repeated then and there. For such a repetition is not permissible unless some further indications against the accused should transpire. But there is nothing to prevent a continuation of the torture on another day. Let it be said, we N. Bishop and N. Judge, if he is present, aforesaid, assign to UN such a day for the continuation of the torture, that the truth may be known from your own mouth. And let all be set down in the process. And during the interval appointed to him, let them use their own persuasions and those of other honest men to induce him to confess the truth. But if he has refused to confess, the torture can be continued on the day assigned, more or less severely according to the gravity of the offenses in question. And the judges will be able to observe many lawful precautions, both in word and deed, by which they may come at the truth, but these are more easily learned by use and experience and the variety of different cases than by the art of teaching of anyone. But if, after having been fittingly questioned and tortured, he will not discover the truth, let him not be further molested, but be freely allowed to depart. If, however, he confesses, and abides by his confession, and uncovers the truth, acknowledging his guilt and asking the pardon of the Church, then according to the canon ad abolendum he is to be treated as one taken in heresy on his own confession, but penitent, and he must abjure the heresy. And sentence must be pronounced against him as in the case of those who are convicted by their own confession as being taken in heresy. This will be explained in the eighth method of sentencing such, to which the reader may refer. If, on the other hand, he confesses the truth, but is not penitent but obstinately persists in his heresy, but is not a relapsed heretic, then according to the canon, after a decent interval and due warning, he is to be condemned as a heretic and handed over to the secular court to suffer the extreme penalty, as we show later in the 10th method. But if he is a relapsed heretic, he is to be condemned in the way which is again explained in the 10th method, to which the reader may refer. But here it must be particularly noted that in some instances he who is to be questioned confesses nothing against himself before the torture. Nor is anything proved on the strength of which he can be required to abjure the heresy or be condemned as a heretic, and in such cases the above procedure should be adopted, as we have said, immediately. But in other cases the accused is taken in heresy, or he is to be considered either lightly or strongly suspected, and he is not to be tortured in respect of such matters, but if, apart from these, he denies some points which are not proved, but of which there is sufficient indication to warrant his being tortured, and if, having been questioned as to these under torture, he confesses to none of them, he is not on that account to be absolved in accordance with the first method, but he must be proceeded against according to that which has been proved against him, and he or she must abjure the heresy as being one under suspicion of or taken in heresy, as the merits of the process may exact or require. And if, after torture, he confesses all or part of that for which he was tortured, then he must abjure both this and the former heresy which was proved against him, and sentence must be pronounced against him in respect of both of these. Part 3, Third Head, Question XXIII. The fourth method of sentencing, in the case of one accused upon a light suspicion. The fourth method of concluding the process on behalf of the faith is used when, after the merits of the process have been diligently examined in consultation with expert lawyers, the accused is found to rest under only a light suspicion of heresy. And this is when the accused is not taken in heresy, nor is convicted by her own confession or by the evidence of the facts or by the legitimate production of witnesses. and there are no other strong or vehement indications of heresy against her, but only a small and light indications of such a sort as, in the opinion of the court, to engender a light suspicion against her. And such a one must be required to abjure the heresy of which she is accused, and then, if she relapses into heresy, she is not liable to the punishment of backsliders, although she must be more severely punished than would be the case if she had not previously abjured the heresy. See the Canon C. Accusatus. The following procedure shall be followed in such a case. For such an accused, if the matter be a public one, will publicly make the following abjuration in the church: I.N. of such a diocese, a citizen of such a city or place, being on my trial, do swear before you the Lord Bishop of such a city, and upon the holy Gospels placed before me and upon which I set my hand, that I believe in my heart and profess with my lips that holy Catholic and Apostolic faith which the Holy Roman Church believes, confesses, preaches, and observes. Also I swear that I believe in my heart and profess with my lips that the Lord Jesus Christ, in company with all the saints, abominates the wicked heresy of witches, and that all who follow or adhere to it will with the devil and his angels be punished in eternal fire unless they turn their hearts and are reconciled by the penitence of the Holy Church. And there I abjure, renounce, and revoke that heresy of which you, my Lord Bishop, and your officers hold me suspected, namely, that I have been familiar with witches, have ignorantly defended their errors, have held in detestation their inquisitors and prosecutors, or that I have failed to bring their crimes to light. Also I swear that I have never believed the aforesaid heresy, nor do I believe, nor have I adhered, nor do I adhere to it, nor shall I ever believe, adhere to, or teach it, nor do I intend to teach it. And if I should hereafter be guilty of any of the aforesaid practices, which God forbid, I shall willingly submit myself to the punishment provided by law for such who are so forsworn, and I am ready to undergo any penance which you see fit to enjoin me for those words or deeds of mine for which you hold me deservedly suspect, and I swear to fulfill such penance to the best of my strength, and to omit no part of it, so help me God and these holy Gospels. The above abjuration shall be made in the common speech, so that all may understand it. And when it is done, the judge, if he is present, or his deputy shall speak to her in the common speech to the following effect: My son, or daughter, you have not unworthily abjured the suspicion which we entertained of you, and have purged yourself by the aforesaid abjuration. Beware then lest hereafter you fall into the heresy you have abjured. For although, if you should repent, you would not be delivered up to the secular court, since you made your abjuration as one under a light, and not a strong, suspicion, yet you would then be far more severely punished than you would have been if you had not abjured. And you would then rest under a strong instead of a light suspicion. And when you should abjure as such, and afterwards should relapse, you would suffer the due punishment of a backslider, and would without mercy be delivered to the secular court to endure the extreme penalty. But if she makes her abjuration secretly in the chamber of the bishop or judge, which will be the case when the matter is not a public one, she shall abjure in the same manner. And afterwards sentence shall be pronounced as follows: We, by the mercy of God, bishop of such a city, or, if he is present, judge in the territory subject to such a prince, having carefully seen and examined the merits of the process conducted by us against UN, accused before us heresy, find that you have committed such and such, naming them, which render you lightly suspected of heresy, on account of which we have judged it proper to cause you to abjure that heresy as one lightly suspected of it. But not for that can you be dismissed unpunished. and that you may become more careful in the future, having consulted with many eminent persons learned in the law and with religious men, and having carefully weighed and digested the whole matter, having only God before our eyes, and the irrefragable truth of the Holy Catholic faith, and with the Holy Gospels placed before us, that our sentence may proceed as from God's countenance, and that our eyes may see with equity, and sitting in tribunal as judge, we condemn, sentence, or rather impose penance upon you, standing in person here in our presence, in the following manner. Namely, that never hereafter shall you knowingly hold to, associate with, defend in your speech, read, if you are well learned, or hereafter, etc. And let there be set down that which she has committed, on account of which she was held suspected of the crime of heresy. This sentence and penance were given, etc. And let the notary take care that he sets it down in the process that such abjuration was made as by one under a light, not a strong, suspicion of heresy, for otherwise great danger might ensue. Part 3, Third Head, Question XXIV. The fifth manner of sentence, in the case of one under strong suspicion. The fifth method of concluding a process on behalf of the faith is used when she who is accused of heresy, after a careful examination of the merits of the process in consultation with learned lawyers, is found to be strongly suspected of heresy. And this is when the accused is not legally taken in heresy, nor has been convicted by her own confession or by the evidence of the facts or by the legitimate production of witnesses, but strong and weighty indications have been proved against her, by reason of which she is held to be under strong suspicion of heresy. The procedure in such a case is as follows. For such a person should abjure that heresy as one strongly suspected of it, in such a manner that, if she should afterwards relapse, she must be delivered to the secular court to suffer the extreme penalty. And she shall make her abjuration publicly or secretly, according to whether she is publicly or secretly suspected, or by more or less, high or low, as was just said in the case of one under a light suspicion, and she must abjure that specific heresy. And the preparations for such an abjuration should be as follows. When the Sunday comes which has been fixed for the abjuration and the hearing of the sentence or the imposition of the penance, the preacher shall deliver a general sermon. After this, the notary or clerk shall publicly read out the crimes of which the accused has been convicted, and those of which she is strongly suspected as a heretic. Then the judge or his deputy shall say to her, Behold, according to that which has been read, you are strongly suspected by us of such heresy, wherefore it behoves you to purge yourself and abjure the aforesaid heresy. And then the book of the Gospels shall be placed before her, and she shall set her hand upon it, and if she can read competently, she shall be given the following written abjuration, and shall read it in the presence of the whole congregation. But if she cannot read competently, the notary shall read it phrase by phrase, and the accused shall repeat it in a loud and audible voice in the following manner. The notary or clerk shall say, I.N. of such a place, and the accused person shall repeat after him the same words, but always in the vulgar tongue. And so on up to the end of the abjuration. And she shall abjure in the following manner. I.N. of such a place in such a diocese, standing my trial in person in presence of you reverend lords, the bishop of such city and the judge of the territory, subject to the rule of such a lord, upon the holy gospel set before me and touched by my hands. I swear that I believe in my heart and profess with my lips that holy Catholic and Apostolic faith which the Holy Roman Church teaches, professes, preaches, and holds. Also I swear that I believe in my heart and profess with my lips that, etc. And let her pronounce the Catholic article of the faith against that heresy of which she is strongly suspected. For example, If the heresy of witchcraft is in question, let her say as follows: I swear that I believe that not only will simple heretics and schismatics be tortured in fire everlasting, but that those above all will be so punished who are infected with the heresy of witches, who deny before the devil that faith which they received in holy baptism at the font, and practice demoniac lewdness for the fulfillment of their evil desires, inflicting all sorts of injuries upon men and animals and the fruits of the earth. And consequently I abjure, renounce, and revoke that heresy, or rather infidelity, which falsely and mendaciously maintains that there are no witches in the world, and that no one ought to believe that those injuries can be caused with the help of devils, for such infidelity is, as I now recognize, expressly contrary to the decision of our Holy Mother the Church and of all the Catholic doctors, as also against the imperial laws which have decreed that witches are to be burned. Also I swear that I have never persistently believed in the aforesaid heresy, neither do I believe nor adhere to it at the present, nor have I taught it, not intend to teach it, nor shall teach it. Also I swear and promise that I will never do or cause to be done such and such, naming them, of which you hold me strongly suspected as a heretic. And if hereafter, which God forbid, I should do any of the aforesaid, I am ready to undergo the punishment provided by law for backsliders, and I am ready to submit myself to any penance which you decide to impose upon me for those deeds and words of mine for which you hold me strongly suspected of the said heresy. And I swear and promise that I will perform it to the best of my strength, and will omit no part of it, so God and this holy gospel help me. And the said abjuration shall be made in the vulgar tongue so that it may be understood by all, unless it be made only in the presence of clerics with a competent knowledge of the Latin tongue. But if the abjuration be made secretly in the bishop's palace or chamber, when it is not a public matter, it shall be made in a similar manner. And afterwards the bishop shall admonish her as above to beware lest she relapse and incur the penalty of a backslider. And let the notary take care that he set it down how such abjuration was made by such a person as one strongly suspected of heresy, so that, if she should relapse, she may be punished as is proper for a backslider. And when this has been done, let the sentence or penance be pronounced in the following manner: We, N, Bishop of such city, and Brother N. If he is present, Inquisitor of the sin of heresy in the domains subject to the rule of such a prince, especially deputed by the Holy Apostolic See, having in mind that you, N, of such a place in such a diocese, have done such and such, naming them, as lawfully appears from the carefully examined merits of the process, wherefore we reasonably hold you strongly suspected of such heresy, and have caused you to abjure it as one so suspected, being persuaded to that course by considerations of justice and the advice of men skilled in the law. But that you may be more careful in the future nor become more prone to the like practices, and that your crimes may not remain unpunished, and that you may be an example to other sinners, having consulted with many eminent and learned lawyers and masters or doctors of the faculty of theology, having carefully digested the whole matter, and having before our eyes only God and the truth of the Catholic Apostolic faith, having set before us the holy gospel that our judgment may proceed as from God's countenance and our eyes see with equity, and sitting in tribunal as judges, we condemn, or rather impose penance in the following manner upon you, N, standing here in person before us, namely, that you shall never hereafter presume to do, say, or teach such and such things. And let there be set down those things of which she has been convicted, and by reason of which she was strongly suspected of the aforesaid heresy, as well as certain others which, if she were to commit them, would make her guilty of a slight relapse into heresy, but this must be as the particular nature of the case demands and requires. As, for example, that she should never wittingly follow such practices, nor receive those whom she knows to have denied the faith, etc. This sentence was given, etc. But it must be noted that those who are suspected, but not taken in heresy, whether they be strongly or lightly suspected, must not be imprisoned or confined for life. For this is the punishment of those who have been heretics and afterwards repented. But they may, because of their deeds for which they have come under suspicion, be sent to prison for a time, and afterwards, as will be seen, released. Neither are they to be branded with the sign of the cross, for such is the sign of a penitent heretic, and they are not convicted heretics, but only suspected, therefore they are not to be marked in this way. But they can be ordered either to stand on certain solemn days within the doors of a church, or near the altar, while Holy Mass is being celebrated, bearing in their hands a lighted candle of a certain weight, or else to go on some pilgrimage, or something of the kind, according to the nature and requirements of the case. Part 3, Third Head, Question XXV. The sixth kind of sentence, in the case of one who is gravely suspect. The sixth method of bringing to a conclusion a process on behalf of the faith is used when the person accused of heresy, after a careful examination of the merits of the process in consultation with learned lawyers, is found to be gravely suspected of heresy. And this is when the accused is not convicted of heresy by her own confession or by the evidence of the facts or by the legitimate productions of witnesses, but there are indications, not only light or even strong, but very strong and grave, which render her gravely suspected of the said heresy, and by reason of which she must be judged as one gravely suspected of the said heresy. And for a clearer understanding of this, we shall give examples both of a case of simple heresy and of the heresy of witches. For the case would fall under this head in simple heresy if the accused were not lawfully found convicted by his own confession, etc. As above, but for something which he had said or done. As, for example, he may have been summoned in a case not concerning the faith, and have been sentenced to excommunication, and if he should continue obstinate in excommunication for a year or more, he would come under a light suspicion of heresy, for such behavior is not without some suspicion of heresy. But if he should then be summoned on a charge concerning the faith, and should not appear but contumaciously refuse to appear, and therefore be excommunicated, then he would be strongly suspected of heresy, for then the light suspicion would become a strong one. And if he remained obstinate in that excommunication for a year, then he would be gravely suspected of heresy, for then the strong suspicion would become a grave one, against which no defense is admitted. And from that time such a person would be condemned as a heretic, as is shown by the canon, c. Cum contumacia, lib. 6. An example of a grave suspicion in the heresy of witches would be when the accused has said or done anything which is practiced by witches when they wish to bewitch anyone. And it commonly happens that they are constrained to manifest themselves by threatening words, by deeds, by a look or a touch, and this is for three reasons. First, that their sins may be aggravated and more manifest to their judges; secondly, that they may be the more easily seduce the simple; and thirdly, that God may be the more offended and they may be granted more power of injuring men. Therefore a witch must be gravely suspected when, after she has used such threatening words as "I will soon make you feel," or the like, some injury has befallen the person so threatened or his cattle. For then she is not to be considered as lightly suspected, as was the case with those who are familiar with witches, or those who wish to provoke someone to inordinate love. See above where we deal with the 3 degrees of suspicion: light, strong, and grave. Now we must consider what procedure is to be observed in such a case. For in the case of one gravely suspected of simple heresy, the following is the procedure. Although he may not in actual truth be a heretic, since there may not be any error in his understanding, or if there is, he may not cling obstinately to it in his will, nevertheless he is to be condemned as a heretic because of the said grave suspicion, against which no proof is admitted. Such a heretic is condemned in this manner. If he refuses to return and abjure his heresy and give fitting satisfaction, he is delivered to the secular court to be punished. But if he is willing and consents, he abjures his heresy and is imprisoned for life. And the same holds good in the case of one gravely suspected of the heresy of witches. But although the same method in the main is to be observed in the case of one gravely suspected of the heresy of witches, there are some differences. It is to be noted that, if the witch maintains her denial, or claims that she uttered those words not with the implied intention but in a vehement and womanish passion, then the judge has not sufficient warrant to sentence her to the flames, in spite of the grave suspicion. Therefore he must place her in prison, and cause inquiry to be made by proclamation whether she has been known to have done the like before. And if it is found that this is so, he must inquire whether she was then publicly defamed in respect of that heresy, and from this he can proceed further so that, before all else, she may be exposed to an interrogation under the question and torture. And then, if she shows signs of such heresy, or of the taciturnity of witches, as that she should be unable to shed tears, or remain insensible under torture and quickly recover her strength afterwards, then he may proceed with the various precautions which we have already explained where we dealt with such cases. And in case all should fail, then let him take note that, if she has perpetrated the like before, she is not to be altogether released, but must be sent to the squalor of prison for a year, and be tortured, and be examined very often, especially on the more holy days. But if, in addition to this, she has been defamed, then the judge may proceed in the manner already shown in the case of simple heresy, and condemn her to the fire, especially if there is a multitude of witnesses and she had often been detected in similar or other deeds of witchcraft. But if he wishes to be merciful, he may set her a canonical purgation, that she should find 20 or 30 sponsors, sentencing her in such a way that, if she should fail in her purgation, she shall be condemned to the fire as convicted. And the judge can proceed in such a manner. And if she should purge herself, then the judge must sentence her to an abjuration of all heresy, on pain of the punishment for backsliders, together with the perpetual penance, in the following manner. The preparations for the abjuration will be the same as were explained in the fourth and fifth methods of concluding a process on behalf of the faith. Note that in all the following methods of pronouncing sentence, when the judge wishes to proceed in a merciful manner he can act in the way we have already explained. But since secular judges use their own various methods, proceeding with rigor but not always with equity, no fixed rule or method can be given for them as it can for an ecclesiastical judge, who can receive the abjuration and impose a perpetual penance in the following manner, i.n. Of such a place in such a diocese, standing in person before you my venerable lords the bishop of such city and judges, having touched with my hands the holy gospel placed before me. Swear that I believe in my heart and profess with my lips the holy Catholic and Apostolic faith which the Holy Roman Church holds, professes, believes, preaches, and teaches. And consequently I abjure all heresy, and renounce and revoke all who raise themselves against the Holy Roman and Apostolic Church, of whatever sect or error they be. Also I swear and promise that I shall never henceforward do, say, or cause to be done such and such, naming them, which I have done and said, and for which, in my guilt, you hold me gravely suspected of the said heresy. Also I swear and promise that I will perform every penance which you wish to impose upon me for the said crimes to the best of my strength, and that I will not omit any part of it, so help me God and the Holy Gospel. And if, which God forbid, I should hereafter act in contravention of this abjuration, I here and now bind and oblige myself to suffer the due punishments for backsliders, however severe they may be. Let the notary take care to set it down that the said abjuration was made by one gravely suspected of heresy, so that if she should be proved to have relapsed, she should then be judged accordingly and delivered up to the secular court. After this let the bishop absolve her from the sentence of excommunication which she has incurred as one gravely suspected of heresy. For when a heretic returns to the faith and abjures his heresy, he is to be released from the sentence of excommunication which is passed on all heretics. Similarly, such a one as we are considering was condemned as a heretic, as we have said, but after she has abjured her heresy she is to be released from excommunication, and after this absolution she is to be sentenced in the following manner: we n. Bishop of such city, and if he is present, judge in the territory of such lord, seeing that you n. of such a place in such a diocese, have been accused before us of such and such touching the faith, naming them, and that we have proceeded to inform ourselves concerning them as justice demanded by a careful examination of the merits of the process and of all that has been done and said in the present case, have found that you have committed such and such, naming them. Wherefore, and not without reason holding you gravely suspected of such heresy, naming it, we have caused you as one so suspected publicly to abjure all heresy in general, as the canonical sanctions bid us. And since according to those same canonical institutions all such are to be condemned as heretics, but you holding to wiser counsel and returning to the bosom of our Holy Mother the Church have abjured, as we have said, all vile heresy. Therefore we absolve you from the sentence of excommunication by which you were deservedly bound as one hateful to the Church of God. And if with true heart and faith unfeigned you have returned to the unity of the Church, you shall be reckoned from henceforth among the penitent, and as from now are received back into the merciful bosom of the Holy Church. But since it would be most scandalous to pass over with connivant eyes and leave unpunished your offences against God and your injuries to men, for it is a graver matter to offend the divine majesty than a human monarch, and that your crimes may not be an incentive for other sinners, and that you may become more careful in the future and less prone to commit again the aforesaid crimes, and may suffer the less punishment in the next world, we the aforesaid bishop and judge, having availed ourselves of the wise and considered advice of learned men in this matter, sitting in tribunal as judges judging, having before our eyes only God and the irrefragable truth of the holy faith, with the holy Gospels placed before us that our judgment may proceed as from the countenance of God and our eyes see with equity, sentence, and condemn. Or rather impose penance in the following manner upon you n. appearing in person before us on the day and at the hour which was before assigned to you. First, you shall put on over all the garments which you wear a grey-blue garment after the manner of a monk's scapulary, made without a hood either before or behind, and having upon it crosses of yellow cloth 3 palms long and 2 palms wide. And you shall wear this garment over all others for such a length of time, setting a period of 1 or 2 years, more or less as the guilt of the person demands, and in the said garment and crosses you shall stand in the door of such a church at such a time for so long. Or on the 4 major feasts of the glorious Virgin, or in such and such cities in the doors of such and such churches, and we sentence and condemn you for life, or for such a period, to such a prison. Let this be set down as seems most to the honor of the faith, and according to the greater or less guilt and obstinacy of the accused. And we expressly, and in the sure knowledge that it is so ordained by canonical institution, reserve to ourselves the right to mitigate the said penance, to increase it, change it, or remove it, in whole or in part, as often as seems good to us. This sentence was given, etc. And when this has been read, it shall at once be duly put into execution, and she shall be clothed with the aforesaid garment with the crosses as has been said. Part 3, Third Head, Question XXVII. The method of passing sentence upon one who is both suspect and defamed. The seventh method of bringing to a conclusion a process on behalf of the faith is employed when the person accused of the sin of heresy, after a careful examination of the merits of the process in consultation with men learned in the law, is found to be both suspected and defamed of heresy. And this is when the accused is not legally convicted by his own confession or by the evidence of the facts or by the legitimate production of witnesses, but is found to be publicly defamed. And there are also other indications which render him lightly or strongly suspected of heresy, as that he has held much familiarity with heretics. And such a person must, because of his defamation, undergo a canonical purgation, and because of the suspicion against him he must abjure the heresy. The procedure in such a case will be as follows. Such a person, being publicly defamed for heresy, and being in addition to this suspected of heresy by reason of certain other indications, shall first publicly purge himself in the manner which we explained in the second method. Having performed this purgation, he shall immediately, as one against whom there are other indications of the suspected heresy, abjure that heresy in the following manner, having before him, as before, the book of the Gospels, I.N., of such a place in such a diocese. Standing my trial in person before you, my lords, N., bishop of such city and judge in the territory of such prince, having touched with my hands the holy Gospels placed before me, swear that I believe in my heart and profess with my lips that holy apostolic faith which the Roman Church believes, professes, preaches, and observes. And consequently I abjure, detest, renounce, and revoke every heresy which rears itself up against the Holy and Apostolic Church, of whatever sect or error it be, etc., as above. Also I swear and promise that I will never hereafter do or say or cause to be done such and such, naming them, for which I am justly defamed as having committed them, and of which you hold be suspected. Also I swear and promise that I will perform to the best of my strength every penance which you impose on me, nor will I omit any part of it, so help me God and this holy gospel. And if hereafter I should act in any way contrary to this oath and abjuration, which God forbid, I here and now freely submit, oblige, and bind myself to the legal punishment for such, to the limit of sufferance, when it shall have been proved that I have committed such things. But it must be noted that when the indications are so strong as to render the accused, either with or without the aforesaid defamation, strongly suspected of heresy, then he shall, as above, abjure all heresy in general. And if he relapsed into any heresy, he shall suffer the due punishment of a backslider. But if the indications are so small and slight as, even taken together with the said defamation, not to render him strongly, but only lightly, suspected of heresy, then it is enough if he makes not a general abjuration, but specifically abjures that heresy of which he is suspected, so that, if he were to relapse into another form of heresy, he would not be liable to the penalty for backsliders. And even if he were to relapse into the same heresy which he had abjured, he would still not be liable to the said penalty, although he would be more severely punished than would have been the case if he had not abjured. But there is a doubt whether he would be liable to the penalty for backsliders if, after his canonical purgation, he should relapse into the same heresy of which he was canonically purged. And it would seem that this would be so, from the canon law, c. Excommunicamus and c. Ad abolendum. Therefore the notary must take great care to set it down whether such a person has made his abjuration as one under a light or a strong suspicion of heresy, for, as we have often said, there is a great difference between these. And when this has been done, sentence or penance shall be pronounced in the following manner: we, N. Bishop of such city or judge in the territories of such prince, having diligently in mind that you, N. of such a place in such a diocese, have been accused before us of such heresy, naming it, and wishing to inquire judicially whether you have fallen into the said heresy, by examining witnesses, by summoning and questioning you upon oath, and by all convenient means in our power, we have acted and proceeded as it behoved. Having digested, observed, and diligently inspected all the facts, and having discussed the merits of the process of this case, examining all and singular which has been done and said, and having consulted with and obtained the mature opinion of many learned theologians and lawyers, we find that you have been in such place or places publicly defamed by good and sober men for the said heresy, wherefore, as we are bidden by the canonical institutions, we have imposed upon you a canonical purgation by which you and your sponsors have here publicly purged yourself before us. We find also that you have committed such and such, naming them, by reason of which we have just cause to hold you strongly or lightly, let it be said whether it is one or the other, suspected of the said heresy, and therefore we have caused you to abjure heresy as one under such suspicion, here. If he has abjured as one under strong suspicion, let them say all heresy, and if as one under light suspicion, the said heresy. But because we cannot and must not in any way tolerate that which you have done, but are in justice compelled to abominate it, that you may become more careful in the future, and that your crimes may not remain unpunished, and that others may not be encouraged to fall into the like sins, and that the injuries to the Creator may not easily be passed over, therefore against you, and, having so purged yourself and abjured, standing personally in our presence in this place at the time which was assigned to you, we, the aforesaid bishop or judge, sitting in tribunal as judges judging, having before us the holy Gospels that our judgment may proceed as from the countenance of God and our eyes see with equity, pronounce sentence or penance in the following manner, namely, that you must, etc. And let them pronounce sentence as shall seem most to the honor of the faith and the extermination of the sin of heresy, as that on certain Sundays and festivals he must stand at the door of such a church, holding a candle of such a weight, during the solemnization of Holy Mass, with head uncovered and bare feet, and offer the said candle at the altar, and that he must fast on Fridays, and that for a certain period he must not dare to depart from that place, but present himself before the bishop or judge on certain days of the week, and any similar penance which seem to be demanded by the particular nature of his guilt, for it is impossible to give a hard and fast rule. This sentence was given, etc. And let it be put into execution after it has been pronounced, and it can be cancelled, mitigated, or changed as may be required by the condition of the penitent and for his correction and humiliation, for the bishop has this power by law. Part 3, Third Head, Question XXIII. The method of passing sentence upon one who hath confessed to heresy, but is still not penitent. The eighth method of terminating a process on behalf of the faith is used when the person accused of heresy, after a careful examination of the merits of the process in consultation with learned lawyers, is found to have confessed his heresy, but to be penitent, and not truly to have relapsed into heresy. and this is when the accused has himself confessed in a court of law under oath before the bishop and inquisitor that he has for so long lived and persisted in that heresy of which he is accused, or in any other, and has believed in and adhered to it, but that afterwards, being persuaded by the bishop and others, he wishes to be converted and to return to the bosom of the Church, and to abjure that and every heresy, and to make such satisfaction as they require of him, and it is found that he has made no previous abjuration of any other heresy, but is now willing and prepared to abjure. In such a case the procedure will be as follows. Although such a person has for many years persisted in the said heresy and even in others, and has believed and practiced them and led many others into error, yet if at last he has consented to abjure those heresies and to make such satisfaction as the bishop and the ecclesiastical judge shall decree, he is not to be delivered up to the secular court to suffer the extreme penalty, nor, if he is a cleric, is he to be degraded, but he is to admitted to mercy, according to the canon ad abolendum. And after he has abjured his former heresy he is to be confined in prison for life, see the canon excommunicamus, where it provides for the absolution of such. But great care must be taken that he has no simulated a false penitence in order to be received back into the Church. Also the secular court is not at all bound by such a sentence as the above. He shall make his abjuration in the manner already set out, with this difference. He shall with his own mouth confess his crimes before the congregation in church on a feast day, in the following manner. The clerk shall ask him, "Have you for so many years persisted in the heresy of witches?" And he shall answer, "Yes." And then, "Have you done this and this to which you have confessed?" And he shall answer, "Yes." And so on. And finally he shall make his abjuration kneeling on his knees. And since, having been convicted of heresy, he has been excommunicated, after he has by abjuration returned to the bosom of the Church, he is to be granted the grace of absolution, according to the manner used by the bishops with apostolic authority of absolving from the major excommunication. And sentence shall at once be pronounced in the following manner: we, the bishop of such city, or the judge in the territories of such prince, seeing that you, n, of such a place in such a diocese, have been by public report and the information of credible persons accused before us of the sin of heresy, and since you had for many years been infected with that heresy to the great damage of your soul, and because this accusation against you has keenly wounded our hearts, we whose duty it is by reason of the office which we have received to plant the holy Catholic faith in the hearts of men and to keep away all heresy from their minds, wishing to be more certainly informed whether there was any truth in the report which had come to our ears, in order that, if it were true, we might provide a healthy and fitting remedy, proceeded in the best way which was open to us to question and examine witness and to interrogate you on oath concerning that of which you were accused, doing all and singular which was required of us by justice and the canonical sanctions. And since we wished to bring your case to a suitable conclusion, and to have a clear understanding of your past state of mind, whether you were walking in the darkness or in the light, and whether or not you had fallen into the sin of heresy, having conducted the whole process, we summoned together in council before us learned men of the theological faculty and men skilled in both the canon and the civil law, knowing that, according to canonical institution, the judgment is sound which is confirmed by the opinion of many, and having on all details consulted the opinion of the said learned men, and having diligently and carefully examined all the circumstances of the process, we find that you are, by your own confession made on oath before us in the court, convicted of many of the sins of witches. Let them be expressed in detail. But since the Lord in his infinite mercy permits men at times to fall into heresies and errors, not only that learned Catholics may be exercised in sacred arguments, but that they who have fallen from the faith may become more humble thereafter and perform works of penitence. Having carefully discussed the circumstances of this same process, we find that you, at our frequent instance and following the advice of us and other honest men, have with a healthy mind returned to the unity and bosom of the Holy Mother Church, detesting the said errors and heresies, and acknowledging the irrefragable truth of the Holy Catholic faith, laying it to your inmost heart, wherefore, following in his footsteps who wishes that no one should perish, we have admitted you to this adjuration and public abjuration of the said and all other heresies. And having done this, we absolve you from the sentence of major excommunication by which you were bound for your fall into heresy, and reconciling you to the Holy Mother Church we restore you to the sacraments of the Church, provided that with a true heart, and not with simulated faith, you return to the unity of the Church, as we believe and hope that you have done. But because it would be a very scandalous thing to avenge the injuries done to temporal lords and to tolerate the offenses committed against God the Creator of all the heavens, since it is a far greater sin to offend against the Eternal than against a temporal majesty. And that God who pities sinners may have mercy upon you, that you may be an example for others, and that your sins may not remain unpunished, and that you may become more careful in the future, and not more prone but less apt to commit the said and any other crimes, we the said bishop and judge, or judges, on behalf of the faith, sitting in tribunal as judges judging, etc., as above. That you put on a grey-blue garment, etc. Also we sentence and condemn you to perpetual imprisonment, there to be punished with the bread of affliction and the water of distress, reserving to ourselves the right to mitigate, aggravate, change, or remit wholly or in part the said sentence if, when, and as often as it shall seem good to us to do so. This sentence was given, etc. After this the judge shall proceed point by point, pronouncing sentence in the following or some similar manner: My son, your sentence or penance consists in this, that you bear this cross during the whole period of your life. That you stand so bearing it on the altar steps or in the door of such churches, and that you be imprisoned for life on bread and water. But, my son, lest this may seem too hard for you, I assure you that if you patiently bear your punishment you will find mercy with us, therefore doubt not nor despair, but hope strongly. After this, let the sentence be duly executed, and let him put on the said garment and be placed on high upon the altar steps in full view of the people as they go out, surrounded by the officers of the secular court. And at the dinner hour let him be led by the officers to prison, and the rest of the sentence be carried out and duly performed. And after he is led out through the door of the church, let the ecclesiastical judge have no more to do with the matter, and if the secular court be satisfied, it is well, but if not, let it do its pleasure. Part 3, Third Head, Question 18. The method of passing sentence upon one who hath confessed to heresy but is relapsed, albeit now penitent. The ninth method of arriving at a conclusive sentence in a process on behalf of the faith is used when the person accused of heresy, after a careful investigation of the circumstances of the process in consultation with men of good judgment, is found to have confessed her heresy and to be penitent, but that she has truly relapsed. And this is when the accused herself confesses in court before the bishop or judges that she has at another time abjured all heresy, and this is legally proved, and that she has afterwards fallen into such a heresy or error, or that she has abjured some particular heresy, such as that of witches, and has afterwards returned to it, but that following better advice she is penitent, and believes the Catholic faith, and returns to the unity of the Church. Such a one is not, if she humbly ask for them, to be denied the sacraments of penance and the Eucharist, but however much she may repent, she is nevertheless to be delivered up as a backslider to the secular court to suffer the extreme penalty. But it must be understood that this refers to one who had made her abjuration as one manifestly taken in heresy, or as one strongly suspected of heresy, and not to one who has so done as being under only a light suspicion. The following procedure must be observed in this case. When, after mature and careful and, if necessary, repeated investigation by learned men, it has been concluded that the said prisoner has actually and prepense relapsed into heresy, the bishop or judge shall send to the said prisoner in the place of detention 2 or 3 honest men, especially religious or clerics, who are zealous for the faith, of whom the prisoner has no suspicion, but rather places confidence in them, and they shall go in to her at a suitable time and speak to her sweetly of the contempt of this world and the miseries of this life, and of the joys and glory of paradise. And leading up from this, they shall indicate to her on the part of the bishop or judge that she cannot escape temporal death, and that she should therefore take care for the safety of her soul, and prepare herself to confess her sins and receive the sacrament of the Eucharist. And they shall visit her often, persuading her to penitence and patience, strengthening her as much as they can in the Catholic truth, and they shall diligently cause her to confess, so that she may receive the sacrament of the Eucharist at her humble petition. For these sacraments are not to be denied to such offenders. And when she has received these sacraments, and been well disposed by these men to salvation, after 2 or 3 days during which they have strengthened her in the Catholic faith and induced her to repentance, the bishop or judge of that place shall notify the bailiff of the place or the authorities of the secular court, that on such a day at such an hour, not a feast day, he should be with his attendants in such a square or place, but it must be outside a church, to receive from their court a certain backslider whom the bishop and judge will hand over to him. And on the morning of the day fixed, or on the day before, it shall be publicly proclaimed throughout the city of place in those towns and villages where such proclamations are customary, that on such a day at such an hour in such a place there will be a sermon preached in defense of the faith, and that the bishop and other judges will condemn a certain person who has relapsed into the sin of heresy, delivering her up to secular justice. But here it must be considered that, if he who has so relapsed should have been ordained in any holy orders, or should be a priest or a religious of any order, before he is handed over he is to be degraded and stripped of the privileges of his ecclesiastic order. And so, when he has been degraded from all ecclesiastical office, let him be handed over to secular justice to receive his due punishment. When, therefore, such a one is to be degraded from his orders and handed over to the secular court, let the bishop summon together all the prelates and religious men of his diocese. For in this case, though not in others, only the bishop together with the other prelates and religious and learned men of his diocese can degrade one who has received holy orders when he is to be delivered to the secular court, or is to be imprisoned for life for the sin of heresy. On the day appointed for the degrading of the backslider and the handing of him over to the secular court, if he be a cleric, or, if he be a layman, for leaving him to hear his definitive sentence, the people shall gather together in some square or open place outside the church. And the inquisitor shall preach a sermon, and the prisoner shall be set on a high place in the presence of the secular authorities. And if the prisoner be a cleric who is to be degraded, the bishop shall don his pontifical robes, together with the other prelates of his diocese in their vestments and copes. And the prisoner shall be clothed and robed as if he were to minister his office, and the bishop shall degrade him from his order, beginning from the higher and proceeding to the lowest. And just as in conferring holy orders the bishop uses the words ordained by the church, so in degrading him he shall take off his chasuble and stole, and so with the other vestments, using words of a directly opposite meaning. When this degradation has been accomplished, the proceedings must continue in the legal and accustomed manner, and the notary or religious or clerk shall be bidden to read the sentence, which shall be after the following manner. Whether the prisoner be a layman or a degraded cleric, we, and, by the mercy of the God Bishop of such city, and judge in the territories of such prince, seeing that we are legitimately informed that you, and, of such a place in such a diocese, have been before us, or before such bishop and judges, accused of such heresy or heresies, naming them, of which you were lawfully convicted by your own confession and by witnesses, and that you had obstinately persisted in them for so long, but afterwards, listening to better advice, publicly in such a place abjured, renounced, and revoked those heresies in the form provided by the Church, on which account the said bishop and inquisitor, believing that you had truly returned to the bosom of the Holy Church of God, did absolve you from the sentence of excommunication by which you were bound, enjoining upon you a salutary penance if with true heart and faith unfeigned you had returned to the unity of the Holy Church. But whereas after all the aforesaid and the lapse of so many years you are again accused before us and have again fallen into such heresies which you had abjured, naming them, and though it was sore grief to us to hear such things of you, yet we were by justice compelled to investigate the matter, to examine the witnesses, and to summon and question you on oath, proceeding in each and every way as we are bidden by the canonical institutions. And since we wished to conclude this case without any doubt, we convened in solemn council learned men of the theological faculty and men skilled in the canon and the civil law, and in consultation with them maturely and carefully examined all and singular which had been done, said and seen in the process, and diligently discussed each circumstance, weighing all equally in the balance as it behoved us, and we find both by the legitimate evidence of witnesses and by your own confession received in court that you have fallen into the heresies which you had abjured. For we find that you have said or done such and such, let all be named, on account of which, with the concurrence of the said learned men, we have judged and now judge that you are a backslider, according to the canonical institutions, to which we refer in grief and grieve to refer. But since it has come to the knowledge of us and of many honest Catholic men that, by the inspiration of divine grade, you have once more returned to the bosom of the Church and to the truth of the faith, detesting the aforesaid errors and heresies, and with true orthodoxy unfeigned believing and protesting the Catholic faith, we have admitted you to receive the Church's sacraments of penance and the Holy Eucharist at your humble request. But since the Church of God has no more which it can do in respect of you, seeing that it has acted so mercifully towards you in the manner we have said, and you have abused that mercy by falling back into the heresies which you had abjured, therefore we the said bishop and judges, sitting in tribunal as judges judging, having before us the holy Gospels, that our judgment may proceed as from the countenance of God and our eyes see with equity, and having before our eyes only God and the irrefragable truth of the holy faith and the extirpation of the plague of heresy, against you, and, in this place on the day and at the hour before assigned to you for the hearing of your definitive sentence, we pronounce in sentence that you have truly fallen back into the sin of heresy, although you are penitent, and as one truly so relapsed we cast you forth from this our ecclesiastical court, and leave you to be delivered to the secular arm. But we earnestly pray that the said secular court may temper its justice with mercy, and that there be no bloodshed or danger of death. And here the bishop and his assessors shall withdraw, and the secular court shall perform its office. It is to be noted that, although the bishop and inquisitor ought to use their utmost diligence, both by their own efforts and those of others, to induce the prisoner to repent and return to the Catholic faith, yet, after he has repented and it has been decided in council that, though he is penitent, he is nevertheless truly a backslider and as such to be handed over in person to the secular court, they ought not to inform him of such sentence and punishment. Therefore from that time, neither before nor after the sentence should they present themselves before him, that he be not moved in his spirit against them, a thing which is very carefully to be avoided in death of this sort. But, as we have said, let them send to him some honest men, especially those in religious orders, or clerics, in whom he has confidence, and let them inform him of the sentence to come and of his death, and strengthen him in the faith, exhorting him to have patience, and let them visit him after the sentence, and console him and pray with him, and not leave him until he has rendered his spirit to his Creator. Let them, therefore, beware and be on their guard not to do or say anything which may enable the prisoner to anticipate his death, or place themselves in an irregular position. And, as they have burdened themselves with the care of his soul, let them then share also in his punishment and guilt. It must also be remarked that such a sentence which delivers up a person to the secular court ought not to be pronounced on a festival or solemn day, nor in a church, but outside in some open space. For it is a sentence which leads to death, and it is more decent that it should be delivered on an ordinary day and outside the church, for a feast day and the church are dedicated to God. Part 3, Third Head, Question XXIX. The method of passing sentence upon one who hath confessed to heresy but is impenitent, although not relapsed. The 10th method of completing a process on behalf of the faith by a final sentence is used when the person accused of heresy, after a careful examination of the circumstances of the process in consultation with skilled lawyers, is found to have confessed his heresy and to be impenitent, though he has not relapsed into the heresy. Such a case is very rarely found, but yet it has come within the experience of us inquisitors. In such a case, therefore, the bishop and judge must not be in haste to sentence the prisoner, but must keep him well guarded and fettered, and induce him to be converted, even to the extent of several months, showing him that, by remaining impenitent, he will be damned in body and soul. But if neither by comforts nor hardships, nor by threatening nor persuasion, can he be brought to renounce his errors, and the appointed period of grace has expired, let the bishop and judges prepare to deliver or abandon him to the secular court, and they shall give notice to the herald or bailiff or secular authorities that on such a day, not a feast, and at such an hour they should be in such a place with their attendants outside a church, and that they will deliver to them a certain impenitent heretic. None the less they shall themselves make public proclamation in the customary places that on such a day at such a time in the aforesaid place a sermon will be preached in defense of the faith, and that they will hand over a certain heretic to secular justice, and that all should come and be present, being granted the customary indulgences. After this, the prisoner shall be delivered to the secular court in the following manner. But let him first be often admonished to renounce his heresy and repent, but if he altogether refuses, let the sentence be pronounced. We, N, by the mercy of God, bishop of such a city, or judge in the territories of such prince, seeing that you, N, of such a place in such a diocese, have been accused before us by public report and the information of credible persons, naming them, of heresy, and that you have for many years persisted in those heresies to the great hurt of your immortal soul, and since we, whose duty it is to exterminate the plague of heresy, wishing to be more certainly informed of this matter and to see whether you walked in darkness or the light, have diligently inquired into the said accusation, summoning and duly examining you, we find that you are indeed infected with the said heresy. But since it is the chief desire of our hearts to plant the Holy Catholic faith in the hearts of our people, and to eradicate the pest of heresy, we have used diverse and various suitable methods, both by ourselves and by others, to persuade you to renounce your said errors and heresies in which you had stood, were standing, and even now defiantly and obstinately stand with stubborn heart. But since the enemy of the human race is present in your heart, wrapping you up and entangling you in the said errors, and you have refused and yet refused to abjure the said heresies, choosing rather the death of your soul in hell and of your body in this world than to renounce the said heresies and return to the bosom of the Church and cleanse your soul. And since you are determined to remain in your sin, therefore inasmuch as you are bound by the chain of excommunication from the Holy Church, and are justly cut off from the number of the Lord's flock, and are deprived of the benefits of the Church can do no more for you, having done all that was possible. We the said bishop and judges on behalf of the faith, sitting in tribunal as judges judging, and having before us the holy Gospels that our judgment may proceed as from the countenance of God and our eyes see with equity. And having before our eyes only God and the truth of the holy faith and the extirpation of the plague of heresy, on this day and at this hour and place assigned to you for the hearing of your final sentence, we give it as our judgment and sentence that you are indeed an impenitent heretic, and as truly such to be delivered and abandoned to the secular court, wherefore by this sentence we cast you away as an impenitent heretic from our ecclesiastical court, and deliver or abandon you to the power of the secular court, praying the said court to moderate or temper its sentence of death against you. This sentence was given, etc. Part 3, Third Head, Question XXX. Of one who has confessed to heresy, is relapsed, and is also impenitent. The 11th method of concluding and terminating a process on behalf of the faith is used when the person accused of heresy, after a diligent discussion of the circumstances of the process in consultation with learned men, is found to have confessed her heresy, and to be impenitent, and to have relapsed into it. And this is when the accused confesses with her own mouth in court that she believes and has practiced such and such. The procedure in this case is the same as that above, and because she is manifestly a heretic, sentence shall be pronounced in the following manner in the presence of the bishop and judges, we n, by the mercy of God bishop of such city, or judge in the territories of such prince. Seeing that you n, of such a place in such a diocese, were formerly accused before us, or before such and such, our predecessors, of the crime of heresy, naming them, and that you were legally convicted of that crime by your own confession and the testimony of worthy men, and that you obstinately persisted in it for so many years, but that afterwards, having listened to better advice, you publicly abjured those heresies in such a place and in the form required by the Church, on which account the aforesaid bishop and judge, believing that you had truly renounced the said errors and had returned with Catholic faith to the bosom of the Church, granted you the benefit of absolution, releasing you from the sentence of excommunication by which you were formerly bound, and setting you a salutary penance if with true heart and faith unfeigned you remained converted to the unity of the Holy Church, received you back in mercy. For the Holy Church of God is not closed to such as return to her bosom. But after all the aforesaid you have to our great grief been accused before us of having again fallen into those damnable heresies which you formerly abjured in public, yet you have done so and so, naming them, in contravention of the said abjuration and to the damage of your soul, and although we are sore wounded and cut to the heart to have heard such things of you, yet we were in justice compelled to inquire into the matter, to examine the witnesses, and to summon and question you on oath as it behoved us, and in every particular to proceed as we are bidden by the canonical institutions. And as we wished to conclude this case beyond any doubt, we summoned a solemn council of men learned in the theological faculty and of those skilled in the canon and civil laws. And having obtained the mature and considered judgment of the said learned men upon every single particular which had been brought to notice and done in this case, after repeated examination of the whole process and careful and diligent discussion of every circumstance, as law and justice demanded, we find that you are legally convicted both by the evidence of credible witnesses and by your own repeated confession, that you have fallen, and fallen again, into the heresies which you abjured. For we find that you have said or done such and such, naming them, wherefore we have reason, in the opinion of the said learned men, and compelled thereto by your own excesses, to judge you as a backslider according to the canonical decrees. And that we say this with grief, and grieve to say it, he knows from whom nothing is hid and who seeth into the secrets of all hearts. And with all our hearts we desired and still desire to lead you back to the unity of the Holy Church and to drive out from your heart the said foul heresy, that so you may save your soul and preserve your body and soul from the destruction in hell. And we have exerted our utmost endeavor by various fitting methods to convert to salvation, but you have been given up to your sin and led away and seduced by an evil spirit, and have chosen to be tortured with fearful and eternal torment in hell. And that your temporal body should here be consumed in the flames, rather than to give ear to better counsels and renounce your damnable and pestilent errors, and to return to the merciful bosom of our Holy Mother Church. Wherefore, since the Church of God can do nothing more for you, having done all that was possible to convert you, we the bishop and judges named in this cause on behalf of the faith, sitting in tribunal as judges judging. Having before us the holy Gospels, that our judgment may proceed as from the countenance of God and our eyes see with equity, and having before our eyes only God and the honor of the holy Catholic faith. On this day at this hour and place before assigned to you for the hearing of your final sentence, we pronounce judgment upon you and, here present before us, and condemn and sentence you as a truly impenitent and relapsed heretic, and as such to be delivered or abandoned to secular justice, and by this our definitive sentence we cast you out as a truly impenitent and relapsed heretic from our ecclesiastical court, and deliver and abandon you to the power of the secular court, praying that the said secular court will temper or moderate its sentence of death against you. This sentence was give, etc. Part 3, Third Head, Question XXII. Of one taken and convicted, but denying everything. The 12th method of finishing and concluding a process on behalf of the faith is used when the person accused of heresy, after a diligent examination of the merits of the process in consultation with skilled lawyers, is found to be convicted of heresy by the evidence of the facts or by the legitimate production of witnesses, but not by his own confession. That is to say, he may be convicted by the evidence of the facts, in that he has publicly practiced heresy, or by the evidence of witnesses against whom he can take no legitimate exception, yet, though so taken and convicted, he firmly and constantly denies the charge. See Henry of Segaggio on Heresy, question 34. The procedure in such a case is as follows. The accused must be kept in strong durance, fettered and chained, and must often be visited by the officers, both in a body and severally, who will use their own best endeavors and those of others to induce him to discover the truth, telling him that if he refuses and persists in his denial, he will in the end be abandoned to the secular law, and will not be able to escape temporal death. But if he continues for a long time in his denials, the bishop and his officers, now in a body and now severally, now personally and now with the assistance of other honest and upright men, shall summon before them now one witness, now another, and warn him to attend strictly to what he has deposed, and to be sure whether or not he has told the truth, that he should beware lest in damning another temporally he damn himself eternally, that if he be afraid, let him at least tell them the truth in secret, that the accused should not die unjustly. And let them be careful to talk to him in such a way that they may see clearly whether or not his depositions have been true. But if the witnesses, after this warning, adhere to their statements, and the accused maintains his denials, let not the bishop and his officers on that account be in any haste to pronounce a definitive sentence and hand the prisoners over to secular law, but let them detain him still longer, now persuading him to confess, now yet again urging the witnesses, but one at a time, to examine their consciences as well. And let the bishop and his officers pay particular attention to that witness who seems to be of the best conscience and the most disposed to good, and let them more insistently charge him on his conscience to speak the truth whether or not the matter was as he had deposed. And if they see any witness vacillate, or there are any other indications that he has given false evidence, let them attest him according to the counsel of learned men, and proceed as justice shall require. For it is very often found that after a person so convicted by credible witnesses has long persisted in his denials, he has at length relented, especially on being truly informed that he will not be delivered to the secular court, but be admitted to mercy if he confesses his sin. And he has then freely confessed the truth which he had so long denied. And it is often found that the witnesses, actuated by malice and overcome by enmity, have conspired together to accuse an innocent person of the sin of heresy, but afterwards, at the frequent entreaty of the bishop and his officers, their consciences have been stricken with remorse and, by divine inspiration, they have revoked their evidence and confessed that they have out of malice put that crime upon the accused. Therefore the prisoner in such a case is not to be sentenced hastily, but must be kept for a year or more before he is delivered up to the secular court. When a sufficient time has elapsed, and after all possible care has been taken, if the accused who has been thus legally convicted has acknowledged his guilt and confessed in legal form that he hath been for the period stated ensnared in the crime of heresy, and has consented to abjure that and every heresy, and to perform such satisfaction as shall seem proper to the bishop and inquisitor for one convicted of heresy both by his own confession and the legitimate production of witnesses, then let him as a penitent heretic publicly abjure all heresy, in the manner which we have set down in the eighth method of concluding a process on behalf of the faith. But if he has confessed that he hath fallen into such heresy, but nevertheless obstinately adheres to it, he must be delivered to the secular court as an impenitent, after the manner of the 10th method which we have explained above. But if the accused has remained firm and unmoved in his denial of the charges against him, but the witnesses have withdrawn their charges, revoking their evidence and acknowledging their guilt, confessing that they had put so great a crime upon an innocent man from motives of rancor and hatred, or had been suborned or bribed thereto, then the accused shall be freely discharged, but they shall be punished as false witnesses, accusers, or informers. This made clear by Paul of Burgos in his comment on the Canon C. Multorum. And sentence or penance shall be pronounced against them as shall seem proper to the bishop and judges, but in any case such false witnesses must be condemned to perpetual imprisonment on a diet of bread and water, and to do penance for all the days of their life, being made to stand upon the steps before the church door, etc. However, the bishops have power to mitigate or even to increase the sentence after a year or some other period, in the usual manner. But if the accused, after a year or other longer period which has been deemed sufficient, continues to maintain his denials, and the legitimate witnesses abide by their evidence, the bishop and judges shall prepare to abandon him to the secular court, sending to him certain honest men zealous for the faith, especially religious, to tell him that he cannot escape temporal death while he thus persists in his denial, but will be delivered up as an impenitent heretic to the power of the secular court. And the bishop and his officers shall give notice to the bailiff or authority of the secular court that on such a day at such an hour and in such a place, not inside a church, he should come with his attendants to receive an impenitent heretic whom they will deliver to him. And let him make public proclamation in the usual places that all should be present on such a day at such an hour and place to hear a sermon preached on behalf of the faith, and that the bishop and his officer will hand over a certain obstinate heretic to the secular court. On the appointed day for the pronouncement of sentence the bishop and his officer shall be in the place aforesaid, and the prisoner shall be placed on high before the assembled clergy and people so that he may be seen by all, and the secular authorities shall be present before the prisoner. Then sentence shall be pronounced in the following manner: we, N, by the mercy of God, bishop of such city, or judge in the territories of such prince, seeing that you, N, of such a place in such a diocese, have been accused before us of such heresy, naming it, and wishing to be more certainly informed whether the charges made against you were true, and whether you walked in darkness or in the light, we proceeded to inform ourselves by diligently examining the witnesses, by often summoning and questioning you on oath, and admitting an advocate to plead in your defense, and by proceeding in every way as we were bound by the canonical decrees. And wishing to conclude your trial in a manner beyond all doubt, we convened in solemn council men learned in the theological faculty and in the canon and civil laws. And having diligently examined and discussed each circumstance of the process and maturely and carefully considered with the said learned men everything which has been said and done in this present case, we find that you, N, have been legally convicted of having been infected with the sin of heresy for so long a time, and that you have said and done such and such, naming them, on account of which it manifestly appears that you are legitimately convicted of the said heresy. But since we desired, and still desire, that you should confess the truth and renounce the said heresy, and be led back to the bosom of Holy Church and to the unity of the Holy Faith, that so you should save your soul and escape the destruction of both your body and soul in hell, we have by our own efforts and those of others, and by delaying your sentence for a long time, tried to induce you to repent, but you being obstinately given over to wickedness have scorned to agree to our wholesome advice, and have persisted and do persist with stubborn and defiant mind in your contumacious and dogged denials, and this we say with grief, and grieve and mourn in saying it. But since the Church of God has waited so long for you to repent and acknowledge your guilt, and you have refused and still refuse, her grace and mercy can go no farther. Wherefore, that you may be an example to others and that they may be kept from all such heresies, and that such crimes may not remain unpunished, we the bishop and judges named on behalf of the faith, sitting in tribunal as judges judging, and having before us the holy Gospels, that our judgment may proceed as from the countenance of God and our eyes see with equity, and having before our eyes only God and the glory and honor of the holy faith, we judge, declare and pronounce sentence that you standing here in our presence on this day at the hour and place appointed for the hearing of your final sentence, are an impenitent heretic, and as such to be delivered or abandoned to secular justice, and as an obstinate and impenitent heretic we have by this sentence cast you off from the ecclesiastical court and deliver and abandon you to secular justice and the power of the secular court. And we pray that the said secular court may moderate its sentence of death upon you. This sentence was given, etc. The bishop and judges may, moreover, arrange that just men zealous for the faith, known to and in the confidence of the secular court, shall have access to the prisoner while the secular court is performing its office, in order to console him and even yet induce him to confess the truth, acknowledge his guilt, and renounce his errors. But if it should happen that after the sentence, and when the prisoner is already at the place where he is to be burned, he should say that he wishes to confess the truth and acknowledge his guilt, and does so, and if he should be willing to abjure that and every heresy, although it may be presumed that he does this rather from fear of death than for love of the truth, yet I should be of the opinion that he may in mercy be received as a penitent heretic and be imprisoned for life. See the gloss on the chapters Ad Abolendum and Excommunicamus. Nevertheless, according to the rigor of the law, the judges ought not to place much faith in a conversion of this sort, and furthermore, they can always punish him on account of the temporal injuries which he has committed. Part 3, Third Head, Question XXII. Of one who is convicted but who hath fled or who contumaciously absents himself. The 13th and last method of arriving at a definite sentence in a process on behalf of the faith is used when the person accused of heresy, after a diligent discussion of the merits of the process in consultation with learned lawyers, is found to be convicted of heresy, but has made his escape, or defiantly absents himself after the expiration of a set time. And this happens in 3 cases. First, when the accused is convicted of heresy by his own confession, or by the evidence of the facts, or by the legitimate production of witnesses, but has fled, or has absented himself and refused to appear after being legally summoned. Secondly, when a person has been accused and certain information has been laid against him on account of which he rests under some suspicion, even if it be only a light one, and he has been summoned to answer for his faith, and because he has defiantly refused to appear, he is excommunicated, and has stubbornly remained in that excommunication for a year, and always defiantly absents himself. The third case is when someone directly obstructs the bishop's or judge's sentence or process on behalf of the faith, or lends his help, advice, or protection for that purpose, and such a person has been stricken with the sword of excommunication. And if he was obstinately endured that excommunication for a year, he is then to be condemned as a heretic who has defied the administration of justice. In the first case, such a person is, according to the canon Ad Abolendum, to be condemned as an impenitent heretic. In the second and third cases he is not to be judged as an impenitent heretic, but to be condemned as if he were a penitent heretic. And in any of these cases the following procedure should be observed. When such a person has been awaited for sufficient time, let him be summoned by the bishop and his officer in the cathedral church of that diocese in which he has sinned, and in the other churches of that place where he had his dwelling, and especially from where he has fled, and let him be summoned in the following manner: we, and, by the mercy of God, bishop of such diocese, having in our charge the welfare of souls, and having above all the desires of our heart this most earnest desire that in our time in the said diocese the church should flourish and that there should be a fruitful and abundant harvest in that vineyard of the Lord of hosts, which the right hand of the Most High Father has planted in the bosom of the righteous, which the Son of that Father has plentifully watered with his own life-giving blood, which the reviving Spirit the Paraclete has made fruitful within by his wonderful and ineffable gifts, which the whole incomprehensible and ineffable blessed Trinity has endowed and enriched with many very great and holy privileges, but the wild boar out of the forest, by which is meant any sort of heretic, has devoured and despoiled it, laying waste the fair fruit of the faith and planting thorny briars among the vines, and that tortuous serpent, the evil enemy of our human race, who is Satan and the devil, has breathed out venom and poisoned the fruit of the vineyard with the plague of heresy, and this is the field of the Lord. The Catholic Church, to till and cultivate which the only firstborn Son of God the Father descended from the heights of heaven, and sowed it with miracles and holy discourse, going through towns and villages and teaching not without great labor, and he chose as his apostles honest laboring men, and showed them the way, endowing them with eternal rewards, and the Son of God himself expects to gather from that field on the day of the last judgment a plentiful harvest, and by the hands of his holy angels to store it in his holy barn in heaven. But the foxes of Samson, two-faced like them who have fallen into the sin of heresy, having their faces looking both ways but tied together by their burning tails, run about with many torches amidst the fields of the Lord, now white unto harvest and shining with the splendor of the faith, and bitterly despoil them, speeding most cunningly here and there, and with their strong attacks burning, dissipating, and detestation, and subtly and damnably subverting the truth of the holy Catholic faith. Wherefore, since you, are fallen into the damned heresies of witches, practicing them publicly in such place, naming it, and have been by legitimate witnesses convicted of the sin of heresy, or by your own confession received by us in court, and after your capture you have escaped, refusing the medicine of your salvation, therefore we have summoned you to answer for the said crimes in person before us, but you, led away and seduced by a wicked spirit, have refused to appear. Or as follows. Wherefore, since you, have been accused before us of the sin of heresy, and from information received against you we have judged that you are under a light suspicion of that sin, we have summoned you to appear personally before us to answer for the Catholic faith. And since, having been summoned, you have defiantly refused to appear, we excommunicated you and caused you to be proclaimed excommunicate. And in this state you have remained stubborn for a year, or so many years, hiding here and there, so that even now we do not know whither the evil spirit has led you, and though we have awaited you kindly and mercifully, that you might return to the bosom and the unity of the holy faith, you being wholly given up to evil have scorned to do so. Yet we wish and are bound to justice to conclude this case beyond any question. Now can we pass over with connivant eyes your iniquitous crimes? We the bishop and judges in the said cause on behalf of the faith require and strictly command by this our present public edict that you the aforesaid, at present in hiding and runaway and fugitive, shall on such a day of such a month in such a year, in such cathedral church of such diocese, at the hour of terce appear personally before us to hear your final sentence, signifying that, whether you appear or not, we shall proceed to our definitive sentence against you as law and justice shall require. And that our summons may come to your knowledge beforehand and you may not be able to protect yourself with a plea of ignorance, we wish and command that our said present letters, requisition, and summons be publicly affixed to the doors of the said cathedral church. In witness of all which we have ordered these our present letters to be authorized by the impressions of our seals. Given, etc. On the appointed day assigned for the hearing of the final sentence, if the fugitive shall have appeared and consented to abjure publicly all heresy, humbly praying to be admitted to mercy. He is to be admitted if he has not been a backslider, and if he was convicted by his own confession or by the legitimate production of witnesses, he shall abjure and repent as a penitent heretic, according to the manner explained in the 8th method of concluding a process on behalf of the faith. If he was gravely suspected, and refused to appear when he was summoned to answer for his faith, and was therefore excommunicated and had endured that excommunication obstinately for a year, but becomes penitent, let him be admitted, and abjure all heresy. In the manner explained in the 6th method of pronouncing sentence. But if he shall appear, and not consent to abjure, let him be delivered as a truly impenitent heretic to the secular court, as was explained in the 10th method. But if he still defiantly refuses to appear, let the sentence be pronounced in the following manner: we, n. by the mercy of God, Bishop of such city, seeing that you, n. of such a place in such a diocese were accused before us by public report and the information of worthy men of the sin of heresy, we, whose duty it is, proceeded to examine and inquire whether there was any truth in the report which had come to our ears. And finding that you were convicted of heresy by the depositions of many credible witnesses, we commanded that you be brought before us in custody. Here let it be said whether he had appeared and been questioned under oath or not. But afterwards, led away and seduced by the advice of the evil spirit, and fearing to have your wounds wholesomely healed with wine and oil, you fled away, or, if it was the case, you broke from your prison and place of detention and fled away, hiding here and there. And we are altogether ignorant of whither the said evil spirit has led you. Or after this manner. And finding that against you, accused as aforesaid before us of the sin of heresy, there were many indications by reason of which we judged you to be lightly suspected of the said heresy, we summoned you by public edict in such and such churches of such diocese within a certain time assigned to appear in person before to answer to the said charges against you and otherwise on matter concerning the faith. But you, following some mad advice, obstinately refused to appear. And when, as in justice bound, we excommunicated you and caused you to be publicly proclaimed excommunicate, you stubbornly remained in that excommunication for more than a year, and kept hidden here and there, so that we do not know whither the evil spirit has led you. And where the Holy Church of God has long awaited you up to this present day in kindness and mercy, that you might fly to the bosom of her mercy, renouncing your errors and professing the Catholic faith, and be nourished by the bounty of her mercy, but you have refused to consent. Persisting in your obstinacy, and since we wished and still wish, as we ought to do and as justice compels us, to bring your case to an equitable conclusion, we have summoned you to appear in person before us on this day at this hour and place, to hear your final sentence. And since you have stubbornly refused to appear, you are manifestly proved to abide permanently in your errors and heresies, and this we say with grief, and grieve in saying it. But since we cannot and will not delay to do justice, nor may we tolerate so great disobedience and defiance of the Church of God, for the exaltation of the Catholic faith and the extirpation of vile heresy, at the call of justice, and by reason of your disobedience and obstinacy. On this day and at this hour and place heretofore strictly and precisely assigned to you for the hearing of your final sentence, having diligently and carefully discussed each several circumstance of the process with learned men in the theological faculty and in the canon and civil laws, sitting in tribunal as judges judging, having before us the holy Gospels that our judgment may proceed as from the countenance of God and our eyes see with equity, and having before our eyes only God and the irrefragable truth of the holy faith. And following in the footsteps of the blessed Apostle Paul, in these writings we pronounce final sentence against you, n. absent or present, as follows, invoking the name of Christ. We the bishop and judges named on behalf of the faith, whereas the process of this cause on behalf of the faith has in all things been conducted as the laws require, and whereas you, having been legally summoned, have not appeared, and have not by yourself or any other person excused yourself, and whereas you have for a long time persisted and still obstinately persist in the said heresies, and have endured excommunication in the cause of the faith for so many years, and still stubbornly endure it, and whereas the Holy Church of God can do no more for you, since you have persisted and intend to persist in your excommunication and said heresies, therefore, following in the footsteps of the blessed Apostle Paul, we declare, judge and sentence you, absent or present, to be a stubborn heretic, and as such to be abandoned to secular justice. And by this our definitive sentence we drive you from the ecclesiastical court, and abandon you to the power of the secular court, earnestly praying the said court that, if ever it should have you in its power, it will moderate its sentence of death against you. This sentence was give, etc. Here it is to be considered that, if that stubborn fugitive had been convicted of heresy, either by his own confession or by credible witnesses, and had fled before his abjuration, he is by the sentence to be judged an impenitent heretic, and so it must be expressed in the sentence. But if, on the other hand, he had not been convicted, but had been summoned as one under suspicion to answer for his faith, and, because he has refused to appear, has been excommunicated, and has obstinately endured that excommunication for more than a year, and has finally refused to appear, then he is not to be judged a heretic, but as a heretic, and must be condemned as such, and so it must be expressed in the sentence as it is said above. Part 3, Question XXIII. Of the method of passing sentence upon one who has been accused by another who has been or is to be burned at the stake. The 14th method of finally concluding a process on behalf of the faith is used when the person accused of heresy, after a careful discussion of the circumstances of the process with reference to the informant in consultation with learned lawyers, is found to be accused of that heresy only by another who has been or is to be burned. And this can happen in 13 ways in 13 cases. For a person so accused is either found innocent and is to be freely discharged, or she is found to be generally defamed for that heresy, or it is found that, in addition to her defamation, she is to be to some degree exposed to torture, or she is found to be strongly suspected of heresy, or she is found to be at the same time defamed and suspected, and so on up to 13 different cases, as was shown in the 20th question. The first case is when she is accused only by a witch in custody, and is not convicted either by her own confession or by legitimate witnesses, and there are no other indications found by reason of which she can truly be regarded as suspect. In such a case she is to be entirely absolved, even by the secular judge himself, who has either burned the deponent or is about to burn her either on his own authority or on that commissioned to him by the bishop and judge of the ordinary court, and she shall be absolved in the manner explained in the 20th question. The second case is when, in addition to being accused by a witch in custody, she is also publicly defamed throughout the whole village or city, so that she has always labored under that particular defamation, but, after the deposition of the witch, it has become aggravated. In such a case the following should be the procedure. The judge should consider that, apart from the general report, nothing particular has been proved against her by other credible witnesses in the village or town, and although, perhaps, that witch has deposed some serious charges against her, yet, since has lost her faith by denying it to the devil. Judges should give no ready credence to her words, unless there should be other circumstances which aggravate that report, and then the case would fall under the third and following case. Therefore she should be enjoined a canonical purgation, and the sentence should be pronounced as shown in the 21st question. And if the civil judge orders this purgation to be made before the bishop, and ends with a solemn declaration that, if she should fail, then, as an example to others, she should be more severely sentenced by both the ecclesiastical and civil judges, well and good. But if he wishes to conduct it himself, let him command her to find 10 or 20 compurgators of her own class, and proceed in accordance with the second method of sentencing such, except that, if she has to be excommunicated, then he must have recourse to the ordinary, and this would be the case if she refused to purge herself. The third case, then, happens when the person so accused is not convicted by her own confession, not by the evidence of the facts, nor by credible witnesses, nor are there any other indications as to any fact in which she had ever been marked by the other inhabitants of that town or village, except her general reputation among them. But the general report has become intensified by the detention of that witch in custody, as that it is said that she had been her companion in everything and had participated in her crimes. But even so, the accused firmly denies all this, and nothing of it is known to other inhabitants, or of anything to save good behavior on her part, though her companionship with the witch is admitted. In such a case the following is the procedure. First they are to be brought face to face, and their mutual answers and recriminations noted, to see whether there is any inconsistency in their words by reason of which the judge can decide from her admissions and denials whether he ought to expose her to torture, and if so, he can proceed as in the third manner of pronouncing a sentence, explained in the 22nd question, submitting her to light tortures, at the same time exercising every possible precaution, as we explained at length towards the beginning of this third part, to find out whether she is innocent or guilty. The fourth case is when a person accused in this manner is found to be lightly suspected, either because of her own confession or because of the depositions of the other witch in custody. There are some who include among those who should be thus lightly suspected those who go and consult witches for any purpose, or have procured for themselves a lover by stirring up hatred between married folk, or have consorted with witches in order to obtain some temporal advantage. But such are to be excommunicated as followers of heretics, according to the Canon C. Excommunicamus, where it says, "Similarly we judge those to be heretics who believe in their errors." For the effect is presumed from the facts. Therefore it seems that such are to be more severely sentenced and punished than those who are under a light suspicion of heresy and are to be judged from light conjectures. For example, if they had performed services for witches or carried their letters to them, they need not on that account believe in their errors, yet they have not laid information against them, and they have received wages and veils from them. But whether or not such people are to be included in this case, according to the opinion of learned men the procedure must be as in the case of those under light suspicion, and the judge will act as follows. Such a person will either abjure heresy or will purge herself canonically, as was explained in the fourth method of pronouncing sentence in the 23rd question. However, it seems that the better course is for such a person to be ordered to abjure heresy, for this is more in accordance with the meaning of the Canon C. Excommunicamus, where it speaks of those who are found to be only under some notable suspicion. And if such should relapse, they should not incur the penalty for backsliders. The procedure will be as above explained in the fourth method of sentencing. The fifth case is when such person is found to be under a strong suspicion, by reason, as before, of her own confession or of the depositions of the other witch in custody. In this class some include those who directly or indirectly obstruct the court in the process of trying a witch, provided that they do this wittingly. Also they include all who give help, advice, or protection to those who cause such obstructions. Also those who instruct summoned or captured heretics to conceal the truth or in some way falsify it. Also all those who wittingly receive, or visit those whom they know to be heretics, or associate with them, send them gifts, or show favor to them, for all such actions, when done with full knowledge, bespeak favor felt towards the sin, and not to the person. And therefore they say that, when the accused is guilty of any of the above actions, and has been proved so after trial, then she should be sentenced in the fifth method, explained in the 24th question, so that she must abjure all heresy, under pain of being punished as a backslider. As to these contentions we may say that the judge must take into consideration the household and family of each several witch who has been burned or is detained, for these are generally found to be infected. For witches are instructed by devils to offer to them even their own children, therefore there can be no doubt that such children are instructed in all manner of crimes, as is shown in the first part of this work. Again, in a case of simple heresy it happens that, on account of the familiarity between heretics who are akin to each other, when one is convicted of heresy it follows that his kindred also are strongly suspected, and the same is true of the heresy of witches. But this present case is made clear in the chapter of the canon Inter Sollicitudines. For a certain dean was, owing to his reputation as a heretic, enjoined a canonical purgation. On account of his familiarity with heretics, he had to make a public abjuration, and through the scandal he was deprived of his benefice, so that the scandal might be allayed. The sixth case is when such a person is under a grave suspicion, but no simple and bare deposition by another witch in custody can cause this, for there must be in addition some indication of the facts, derived from certain words or deeds uttered or committed by the witch in custody, in which the accused is at least said to have taken some part, and shared in the evil deeds of the deponent. To understand this, the reader should refer to what was written in the 19th question, especially concerning the grave degree of suspicion, how it arises from grave and convincing conjectures, and how the judge is forced to believe, on mere suspicion, that a person is a heretic, although perhaps in his heart he is a true Catholic. The canonists give an example of this by the case, in simple heresy, of a man summoned to answer in the cause of the faith, and defiantly refusing to appear, on which account he is excommunicated, and if he persists in that state for a year, becomes gravely suspected of heresy. And so likewise in the case of person accused in the way we are considering, the indications of the facts are to be examined by which she is rendered gravely suspect. Let us put the case that the witch in custody has asserted that the accused has taken part in her evil works of witchcraft, but the accused firmly denies it. What then is to be done? It will be necessary to consider whether there are any facts to engender a strong suspicion of her, and whether that strong suspicion can become a grave one. Thus, if a man has been summoned to answer some charge, and has obstinately refused to appear, he would come under a light suspicion of heresy, even if he had not been summoned in a cause concerning the faith. But if he then refused to appear in a cause concerning the faith and was excommunicated for his obstinacy, then he would be strongly suspected, for the light suspicion would become a strong one, and if then he remained obstinate in excommunication for a year, the strong suspicion would become a grave one. Therefore the judge will consider whether, by reason of her familiarity with the witch in custody, the accused is under a strong suspicion, in the manner shown in the fifth case above, and then he must consider whether there is anything which may turn that strong suspicion into a grave one. For it is presumed that it is possible for this to be the case, on account of the accused having perhaps shared in the crimes of the detained witch, if she has had frequent intercourse with her. Therefore the judge must proceed as in the sixth method of sentencing explained in the 25th question. But it may be asked what the judge is to do if the person so accused by a witch in custody still altogether persists in her denials, in spite of all indications against her. We answer as follows. First, the judge must consider whether those denials do or do not proceed from the vice or witchcraft of taciturnity, and, as was shown in the 15th and 16th questions of this third part, the judge can know this from her ability or inability to shed tears, or from her insensibility under torture and quick recovery of her strength afterwards. For then the grave suspicion would be aggravated, and in such a case she is by no means to be freely discharged, but, according to the sixth method of sentencing, she must be condemned to perpetual imprisonment and penance. But if she is not infected with the taciturnity of witches, but feels the keenest pains in her torture, whereas others, as has been said, become insensible to pain owing to the witchcraft of taciturnity, then the judge must fall back upon his last expedient of a canonical purgation. And if this should be ordered by a secular judge, it is called a lawful vulgar purgation, since it cannot be classed with other vulgar purgations. And if she should fail in this purgation, she will be judged guilty. The seventh case is when the accused is not found guilty by his own confession, by the evidence of the facts, or by legitimate witnesses, but is only found to be accused by a witch in custody, and there are also some indications found which bring him under light or strong suspicion. As, for example, that he had had great familiarity with witches, in which case he would, according to the canon, have to undergo a canonical purgation on account of the general report concerning him, and on account of the suspicion against him he must abjure heresy, under pain of being punished as a backslider if it was a strong suspicion, but not if it was a light one. The eighth case occurs when the person so accused is found to have confessed that heresy, but to be penitent, and never to have relapsed. But here it is to be noted that in this and the other cases, where it is a question of those who have or have not relapsed, and who are or are not penitent, these distinctions are made only for the benefit of judges who are not concerned with the infliction of the extreme penalty. Therefore the civil judge may proceed in accordance with the civil and imperial laws, as justice shall demand, in the case of one who has confessed, no matter whether or not she be penitent, or whether or not she have relapsed. Only he may have recourse to those 13 methods of pronouncing sentence, and act in accordance with them, if any doubtful question should arise. Part 3, Third Head, Question 30. Of the method of passing sentence upon a witch who annuls spells wrought by witchcraft, and of witch midwives and archer wizards. The 15th method of bringing a process on behalf of the faith to a definitive sentence is employed when the person accused of heresy is not found to be one who casts injurious spells of witchcraft, but one who removes them, and in such a case the procedure will be as follows. The remedies which she uses will either be lawful or unlawful, and if they are lawful, she is not to be judged a witch but a good Christian. But we have already shown at length what sort of remedies are lawful. Unlawful remedies, on the other hand, are to be distinguished as either absolutely unlawful, or in some respect unlawful. If they are absolutely unlawful, these again can be divided into two classes, according as they do or do not involve some injury to another party, but in either case they are always accompanied by an expressed invocation of devils. But if they are only in some respect unlawful, that is to say, if they are practiced with only a tacit, and not an expressed, invocation of devils, such are to be judged rather vain than unlawful, according to the canonists and some theologians, as we have already shown. Therefore the judge, whether ecclesiastical or civil, must not punish the first and last of the above practices, having rather to commend the first and tolerate the last, since the canonists maintain that it is lawful to oppose vanity with vanity. But he must by no means tolerate those who remove spells by an expressed invocation of devils, especially those who in doing so bring some injury upon a third part, and this last is said to happen when the spell is taken off one person and transferred to another. And we have already made it clear in a former part of this work that it makes no difference whether the person to whom the spell is transferred be herself a witch or not, or whether or not she be the person who cast the original spell, or whether it be a man or any other creature. It may be asked what the judge should do when such a person maintains that she removes spells by lawful and not unlawful means, and how the judge can arrive at the truth of such a case. We answer that he should summon her and ask her what remedies she uses, but he must not rely only upon her word, for the ecclesiastical judge whose duty it is must make diligent inquiry, either himself or by means of some parish priest who shall examine all his parishioners after placing them upon oath, as to what remedies she uses. And if, as is usually the case, they are found to be superstitious remedies, they must in no way be tolerated, on account of the terrible penalties laid down by the canon law, as will be shown. Again, it may be asked how the lawful remedies can be distinguished from the unlawful, since they always assert that they remove spells by certain prayers and the use of herbs. We answer that this will be easy, provided that a diligent inquiry be made. For although they must necessarily conceal their superstitious remedies, either that they may not be arrested, or that they may the more easily ensnare the minds of the simple, and therefore make great show of their use of prayers and herbs, yet they can be manifestly convicted by for superstitious actions as sorceresses and witches. For there are some who can divine secrets, and are able to tell things which they could only know through the revelation of evil spirits. For example, when the injured come to them to be healed, they can discover and make known the cause of their injury, and they can perfectly know this and tell it to those who consult them. Secondly, they sometimes undertake to cure the injury or spell of one person, but will have nothing to do with that of another. For in the diocese of Spires there is a witch in a certain place called Zunhofen who, although she seems to heal many persons, confesses that she can in no way heal certain others, and this is for no other reason than, as the inhabitants of the place assert, that the spells case on such person have been so potently wrought by other witches with the help of devils that the devils themselves cannot remove them. For one devil cannot or will not always yield to another. Thirdly, it sometimes happens that they must make some reservation or exception in their cure of such injuries. Such a case is known to have occurred in the town of Spires itself. An honest woman who had been bewitched in her shins sent for a diviner of the sort to come and heal her, and when the witch had entered her house and looked at her, she made such an exception. For she said, "If there are no scales and hairs in the wound, I could take out all the other evil matter." And she revealed the cause of the injury, although she had come from the country from a distance of 2 miles, saying, "You quarreled with your neighbor on such a day, and therefore this had happened to you." Then, having extracted from the wound many other matters of various sorts, which were not scales or hairs, she restored her to health. Fourthly, they sometimes themselves observe, or cause to be observed, certain superstitious ceremonies. For instance, they fix some such time as before sunrise for people to visit them, or say that they cannot heal injuries which were caused beyond the limits of the estate on which they live, or that they can only heal 2 or 3 persons in a year. Yet they do not heal them, but only seem to do so by creasing to injure them. We could add many other considerations as touching the condition of such persons, as that, after the lapse of a certain time they have incurred the reputation of leading a bad and sinful life, or that they are adulteresses, or the survivors from covens of other witches. Therefore their gift of healing is not derived from God on account of the sanctity of their lives. Here we must refer incidentally to witch midwives, who surpass all other witches in their crimes, as we have shown in the first part of this work. And the number of them is so great that, as has been found from their confessions, it is thought there is scarcely any tiny hamlet in which at least one is not to be found. And that the magistrates may in some degree meet this danger, they should allow no midwife to practice without having been first sworn as a good Catholic, at the same time observing the other safeguards mentioned in the second part of this work. Here too we must consider archer-wizards, who constitute the graver danger to the Christian religion in that they have obtained protection on the estates of nobles and princes who receive, patronize, and defend them. But that all such receivers and protectors are more damnable than all witches, especially in certain cases, is shown as follows. The canonists and theologians divide into two classes the patrons of such archer-wizards, according as they defend the error or the person. They who defend the error are more damnable than the wizards themselves, since they are judged to be not only heretics but heresiarches. 24, Quest. 3. And the laws do not make much special mention of such patrons, because they do not distinguish them from other heretics. But there are others who, while not excusing the sin, yet defend the sinner. These, for example, will do all in their power to protect such wizards, or other heretics, from trial and punishment at the hands of the judge acting on behalf of the faith. Similarly, there are those in public authority, that is to say, public persons such as temporal lords, and also spiritual lords who have temporal jurisdiction, who are, either by omission or commission, patrons of such wizards and heretics. They are their patrons by omission when they neglect to perform their duty in regard to such wizards and suspects, or to their followers, receivers, defenders, and patrons, when they are required by the bishops or inquisitors to do this, that is, by failing to arrest them. By not guarding them carefully when they are arrested, by not taking them to the place within their jurisdiction which has been appointed for them, by not promptly executing the sentence passed upon them, and by other such derelictions of their duty. They are their patrons by commission when, after such heretics have been arrested, they liberate them from prison without the license or order of the bishop or judge, or when they directly or indirectly obstruct the trial, judgment, and sentence of such, or act in some similar way. The penalties for this have been declared in the second part of this work, where we treated of archer-wizards and other enchanters of weapons. It is enough now to say that all these are by law excommunicated, and incur the 12 great penalties. And if they continues obstinate in that excommunication for a year, they are then to be condemned as heretics. Who, then, are to be called receivers of such, and are they to be reckoned as heretics? All they, we answer, who receive such archer-wizards, enchanters of weapons, necromancers, or heretic witches as are the subject of this whole work. And such receivers are of two classes, as was the case with the defenders and patrons of such. For there are some who do not receive them only once or twice, but many times and often, and these are well called in Latin receptatores, from the frequentative form of the verb. And receivers of this class are sometimes blameless, since they act in ignorance and there is no sinister suspicion attaching to them. But sometimes they are to blame, as being well aware of the sins of those whom they receive, for the Church always denounces these wizards as the most cruel enemies of the faith. And if nevertheless temporal lords receive, keep, and defend them, etc., they are and are rightly called receivers of heretics. And with regard to such, the laws say that they are to be excommunicated. But others there are who do not often or many times receive such wizards or heretics, but only once or twice, and these are not properly called receptatores, but receptores, since they are not frequent receivers. Yet the archdeacon disagrees with this view, but it is no great matter, for we are considering not words but deeds. But there is this difference between receptatores and receptores: those temporal princes are always receptatores who simply will not or cannot drive away such heretics. But receptores may be quite innocent. Finally, it is asked who are they who are said to be obstructors of the duty of inquisitors and bishops against such heretics, and whether they are to be reckoned as heretics. We answer that such obstructors are of two kinds. For there are some who cause a direct obstruction, by rashly on their own responsibility releasing from jail those who have been detained on a charge of heresy, or by interfering with the process of the Inquisition by wreaking some injury to witnesses on behalf of the faith because of the evidence they have given, or it may be that the temporal lord issues an order that none but himself may try such a case, and that anyone charged with this crime should be brought before no one but himself, and that the evidence should be given only in his presence, or some similar order. And such, according to Giovanni d'Andrea, are direct obstructors. They who directly obstruct the process, judgment, or sentence on behalf of the faith, or help, advise or favor others in doing so, although they are guilty of a great sin, are not on that account to be judged heretics, unless it appears in other ways that they are obstinately and willfully involved in such heresies of witches. But they are to be smitten with the sword of excommunication, and if they stubbornly endure that excommunication for a year, then are they to be condemned as heretics. But others are indirect obstructors. These, as Giovanni d'Andrea explains, are those who give such orders as that no one shall bear arms for the capture of heretics except the servants of the said temporal lord. Such are less guilty than the former, and are not heretics, but they, and also any who advise, help, or patronize them in such actions, are to be excommunicated, and if they obstinately remain in that excommunication for a year, they are then to be condemned as if they were heretics. And here it is to be understood that they are in such a way to be condemned as heretics that if they are willing to return, they are received back to mercy, having first abjured their error, but if not, they are to be handed over to the secular court as impenitents. To sum up, witch midwives, like other witches, are to be condemned and sentences according to the nature of their crimes, and this is true also of those who, as we have said, remove spells of witchcraft superstitiously and by the help of devils, for it can hardly be doubted that, just as they are able to remove them, so can they inflict them. And it is a fact that some definite agreement is formed between witches and devils whereby some shall be able to hurt and others to heal, that so they may more easily ensnare the minds of the simple and recruit the ranks of their abandoned and hateful society. Archer-wizards and enchanters of weapons, who are only protected by being patronized, defended, and received by temporal lords, are subject to the same penalties, and they who patronize them, etc., or obstruct the officers of justice in their proceedings against them, are subject to all the penalties to which the patrons of heretics are liable, and are to be excommunicated. And if after they have obstinately endured that excommunication for a year they wish to repent, let them abjure that obstruction and patronage, and if not, they must be handed over as impenitents to the secular court. And even if they have not endured their excommunication for a year, such obstructors can still be proceeded against as patrons of heretics. And all that has been said with regard to patrons, defenders, receivers, and obstructors in the case of archer-wizards, etc., applies equally in respect of all other witches who work various injuries to men, animals, and the fruits of the earth. But even the witches themselves, when in the court of conscience with humble and contrite spirit they weep for their sins and make clean confession asking forgiveness, are taken back to mercy. But when they are known, those whose duty it is must proceed against them, summoning, examining, and detaining them, and in all things proceeding in accordance with the nature of their crimes to a definitive and conclusive sentence, as has been shown. If they wish to avoid the snare of eternal damnation by reason of the excommunication pronounced upon them by the Church when they deliberately fail in their duty. Part 3, Question XXXV. Finally, of the method of passing sentence upon witches who enter or cause to be entered an appeal, whether such be frivolous or legitimate and just. But if the judge perceives that the accused is determined to have recourse to an appeal, he must first take note that such appeals are sometimes valid and legitimate, and sometimes entirely frivolous. Now it has already been explained that cases concerning the faith are to be conducted in a simple and summary fashion, and therefore that no appeal is admitted in such cases. Nevertheless, it sometimes happens that judges, on account of the difficulty of the case, gladly prorogue and delay it. Therefore they may consider that it would be just to allow an appeal when the accused feels that the judge has really and actually acted towards him in a manner contrary to the law and justice, as that he has refused to allow him to defend himself, or that he has proceeded to a sentence against the accused on his own responsibility and without the counsel of others, or even without consent of the bishop or his vicar, when he might have taken into consideration much further evidence both for and against. For such reasons an appeal may be allowed, but not otherwise. Secondly, it is to be noted that, when notice of appeal has been given, the judge should, without perturbation or disturbance, ask for a copy of the appeal, giving his promise that the matter shall not be delayed. And when the accused has given him a copy of the appeal, the judge shall notify him that he has yet 2 days before he need answer it, and after those 2 days 30 more before he need prepare the apostilles of the case. And although he may give his answer at once, and at once proceed to issue his apostilles if he is very expert and experienced, yet it is better to act with caution, and fix a term of 10 or 20 or 25 days. Reserving to himself the right to prorogue the hearing of the appeal up to the legal limit of time. Thirdly, let the judge take care that during the legal and appointed interval he must diligently examine and discuss the causes of the appeal and the alleged grounds of objection. And if after having taken good counsel he sees that he has unduly and unjustly proceeded against the accused, by refusing him permission to defend himself, or by exposing him to questions at an unsuitable time, or for any such reason, when the appointed time comes let him correct his mistake, carrying the process back to the point and stage where it was when the accused asked to be defended, or when he put a term to his examination, etc., and so remove the objection, and then let him proceed as we have said. For by the removal of the grounds for objection the appeal, which was legitimate, loses its weight. But here the circumspect and provident judge will carefully take note that some grounds of objection are reparable, and they are such as we have just spoken of, and are to be dealt with in the above manner. But others are irreparable, as when the accused has actually and in fact been questioned, but has afterwards escaped and lodged an appeal, or that some box or vessel or such instruments as which's use has been seized and burned, or some other such irreparable and irrevocable action has been committed. In such a case the above procedure would not hold good, namely, taking the process back to the point where the objection arose. Fourthly, the judge must note that, although 30 days may elapse between his receiving the appeal and his completing the apostilles of the case, and he can assign to the petitioner the last day, that is, the 30th, for the hearing of his appeal, yet, that it may not seem that the wishes to molest the accused or some under suspicion of unduly harsh treatment of him, and that his behavior may not seem to lend support to the objection which has caused the appeal, it is better that he should assign some day within the legal limit, such as the 10th or 20th day, and he can afterwards, if he does not wish to be in a hurry, postpone it until the last legal day, saying that he is busy with other affairs. Fifthly, the judge must take care that, when he affixes a term for the accused who is appealing and petitioning for apostilles, he must provide not only for the giving, but both for the giving and receiving of apostilles. For if he provided only for the giving of them, then the judge against whom the appeal is lodged would have to discharge the appellant. Therefore let him assign to him a term, that is, such a day of such a year, for the giving and receiving from the judge such apostilles as he shall have decided to submit. Sixthly, he must take care that, in assigning this term, he shall not in his answer say that he will give either negative or affirmative apostilles, but that he may have opportunity for fuller reflection, let him say that he will give such as he shall at the appointed time have decided upon. Let him also take care that in assigning this term to the appellant he give the appellant no opportunity to exercise any malicious precautions or cunning, and that he specify the place, day, and hour. For example, let him assign the 20th day of August, in the present year, at the hour of vespers, and the chamber of the judge himself in such a house, in such a city, for the giving and receiving of apostilles such as shall have been decided upon for such appellant. Seventhly, let him note that, if he has decided in his mind that the charge against the accused justly requires that he should be detained, in assigning the term he must set it down that he assigns that term for the giving or receiving of apostilles by the appellant in person, and that he assigns to the said appellant such a place for giving to him and receiving from him apostilles, and then it will be fully in the power of the judge to detain the appellant, granted that he has first given negative apostilles, but otherwise it will not be so. Eighthly, let the judge take care not to take any further action in respect of the appellant, such as arresting him, or questioning him, or liberating him from prison, from the time when the appeal is presented to him up to the time when he has returned negative apostilles. To sum up, note that it often happens that, when the accused is in doubt as to what sort of sentence he will receive, since he is conscious of his guilt, he frequently takes refuge in an appeal, that so he may escape the judge's sentence. Therefore he appeals from that judge, advancing some frivolous reason, as that the judge held him in custody without allowing him the customary surety, or in some such way he may color his frivolous appeal. In this case the judge shall ask for a copy of the appeal, and having received it he shall either at once or after 2 days give his answer and assign to the appellant for the giving and receiving of such apostilles as shall have been decided upon a certain day, hour, and place, within the legal limit, as, for instance, the 25th, 26th or 30th day of such a month. And during the assigned interval the judge shall diligently examine the copy of the appeal, and the reasons or objections upon which it is based, and shall consult with learned lawyers whether he shall submit negative apostilles, that is, negative answers, and thereby disallow the appeal, or whether he shall allow the appeal and submit affirmative and fitting apostilles to the judge to whom the appeal is made. But if he sees that the reasons for the appeal are frivolous and worthless, and that the appellant only wishes to escape or to postpone his sentence, let his apostilles be negative and refutatory. If, however, he sees that the objections are true and just, and not irreparable, or if he is in doubt whether the accused is maliciously causing him trouble, and wishes to clear himself of all suspicion, let him grant the appellant affirmative and fitting apostilles. And when the appointed time for the appellant has arrived, if the judge has not prepared his apostilles or answers, or in some other way is not ready, the appellant can at once demand that his appeal be heard, and may continue to do so on each successive day up to the 30th, which is the last day legally allowed for the submission of the apostilles. But if he has prepared them and is ready, he can at once give his apostilles to the appellant. If, then, he has decided to give negative or refutatory apostilles, he shall, at the expiration of the appointed time, submit them in the following manner, and the said judge, answering to the said appeal, if it may be called an appeal, says that he, the judge, has proceeded and did intend to proceed in accordance with the canonical decrees and the imperial statutes and laws, and has not departed from the path of either law nor intended so to depart, and has in no way acted or intended to act unjustly towards the appellant. As is manifest from an examination of the alleged grounds for this appeal. For he has not acted unjustly towards him by detaining him and keeping him in custody, for he was accused of such heresy, and there was such evidence against him that he was worthily convicted of heresy, or was strongly suspected. And as such it was and is just that he should be kept in custody, neither has he acted unjustly by refusing him sureties, for the crime of heresy is one of the more serious crimes, and the appellant had been convicted but persisted in denying the charge. And therefore not even the very best sureties were admissible, but he is and was to be detained in prison. And so he shall proceed with the other objections. Having done this, let him say as follows: wherefore it is apparent that the judge has duly and justly proceeded, and has not deviated from the path of justice, and has in no way unduly molested the appellant, but the appellant, advancing pretended and false objections, has by an undue and unjust appeal attempted to escape his sentence. Wherefore his appeal is frivolous and worthless, having no foundation, and erring in matter and form. And since the laws do not recognize frivolous appeals, nor are they to be recognized by the judge, therefore the judge has himself said that he does not admit and does not intend to admit the said appeal, nor does he recognize nor yet propose to recognize it. And he gives this answer to the said accused who make this undue appeal in the form of negative apostilles, and commands that they be given to him immediately after the said appeal. And so he shall give it to the notary who has presented the appeal to him. And when these negative apostilles have been given to the appellant, the judge shall at once proceed with his duty, ordering the accused to be seized and detained, or assigning to him a day to appear before him, as shall seem best to him. For he does not cease to be the judge, but shall continue his process against the appellant until the judge to whom the appeal was made shall order him to cease. But let the judge take care not to commence any new proceedings against the appellant, by arresting him or, if he is in custody, liberating him from prison, from the time of the presentation of the appeal up to the time of the return of negative apostilles to him. But after that time, as we have said, he can do so if justice requires it, until he is prevented by the judge to whom the appeal has been made. Then, with the process sealed under cover, and with a sure and safe escort and if necessary a suitable surety, let him send him to the said judge. But if the judge has decided to return affirmative and fitting apostilles, let him submit them in writing in the following manner on the arrival of the day appointed for the giving and receiving of apostilles, and the said judge, answering to the said appeal. If it may be called an appeal, says that he has proceeded in the present cause justly and as he ought and not otherwise, nor has he molested or intended to molest the appellant, as is apparent from a perusal of the alleged objections. For he has not molested him by, etc. Here he shall answer to each of the objections in the appeal, in the best and most truthful manner that he can. Wherefore it is apparent that the said judge has in no way dealt unjustly by the appellant nor given him cause to appeal, but that the appellant is afraid lest justice should proceed against him according to his crimes. And therefore the appeal is frivolous and worthless, having no foundation, and not being admissible by the laws or the judge. But in reverence for the apostolic see, to which the appeal is made, the said judge says that he admits the appeal and intends to recognize it, deferring the whole matter to Outmost Holy Lord the Pope, and leaving it to the Holy Apostolic See, assigning to the said appellant a certain time, namely, so many months now following, within which, with the process sealed under cover given to him by the said judge, or having given suitable sureties to present himself at the court of Rome, or under a sure and safe escort appointed to him by the said judge. He must present himself in the court of Rome before our Lord the Pope. And this answer the said judge gives tot he said appellant as affirmative apostiles, and orders that it be given to him immediately after the appeal presented to him. And so he shall hand it to the notary who has presented the appeal to him. The prudent judge must here take note that, as soon as he has given these fitting apostiles to the appellant, he at once ceases to be the judge in that cause from which the appeal was made, and can proceed no further in it, unless it be referred back to him by our most holy Lord the Pope. Therefore let him have no more to do with that case, except to send the said appellant in the above manner to our Lord the Pope, assign to him a convenient time, say 1, 2 or 3 months, within which he must prepare and make himself ready to appear and present himself at the court of Rome. Giving a suitable surety, or, if he cannot do this, let him be sent under a sure and safe escort. For he must either bind himself by the best means in his power to present himself within the assigned time before our Lord the Pope in the court of Rome, or his appeal must necessarily fall to the ground. But if the judge has another case, and proceeds against the accused in another case in which he has not lodged any appeal, in that other case he remains, as before, judge. And even if, after the appeal has been admitted, and the affirmative apostiles have been given, the appellant is accused and denounced to the judge in respect of other heresies which were not in question in the case from which he appealed, he does not cease to be the judge, and can proceed with the inquiry and the examination of witnesses as before. And when the first case has been finished in the court of Rome, or after reference back to the judge, he is free to proceed with the second. Let judges also take care that they send the process to the court of Rome, sealed and under cover, to the judges appointed to execute justice, together with a digest of the merits of the process. And inquisitors should not concern themselves to appear at Rome against the appellants, but should leave them to their own judges, who, if the inquisitors are unwilling to appear against the appellants, shall provide their own advocates for the appellant, if they wish to expedite the case. Let judges also take note that, if they are personally summoned by the appellant, and appear, they must beware at all costs against engaging in litigation, but must leave the whole process and cause to those judges, and so manage that they may be able to return as soon as possible, so that they may not be sorely troubled with fatigues, misery, labor, and expense in Rome. For by this means much damage is caused to the Church, and heretics are greatly encouraged, and thereafter judges will not receive so much respect and reverence, not will they be so much feared as before. Also other heretics, seeing the judges fatigued and detained in the court of Rome, will exalt their horns, and despise and malign them, and more boldly proclaim their heresies, and when they are accused, they will appeal in the same way. Other judges, also, will have their authority weakened when they proceed on behalf of the faith and are zealous in extirpating heretics, since they will fear lest they may be troubled with miseries and fatigues arising from similar appeals. All this is most prejudicial to the faith of the Holy Church of God, wherefore may the spouse of that Church in mercy preserve her from all such injuries.